It is learned. I approached to the mill of the TRT. I filed a section 17 application. I lost. I purchased the agricultural land because my lord knows agricultural land is hit by section 31 of the Surface Act. I lost. I preferred an appeal before the TRAT Kolkata. TRAT Kolkata remanded back to the TRT Siliguri, explaining all the circumstances and to rehear the matter afresh. Again, my lord, I lost the matter before the TRT Siliguri here. During the preferring appeal against the order, second round of litigation, I preferred an appeal before the TRT matter was pending. In the meantime, bank approached a section 14 application before the learned ACGM without disclosing any facts in between what happened. Obtain an order, and then on the day, partially had taken the position. On the next day, my lord, under the circumstances, DRAT was not functioning. Today, as of now, even I have the notification. I approached the 227 application. Then, my lord, after prolonged hearing, my lord Justice Mukherjee passed an order. The interim order is still substituting till 8th of this month. In the meantime, my lord Justice Mukherjee given a liberty to approach the DRT Siliguri so that the matter of section 17 can be taken up. And during the 3 weeks, the interim order will subsist. And the DRT, because the appeal was pending, also given a liberty for mentioning the matter for preponing. Well, after passing the order the next day, I filed section 17 before the DRT Siliguri. Then, you know what DRT said? The matter is fixed on 9, despite recording the order of the Milord, the Honorable Court Milord. Then, Milord, as the interim order expiring on 8, matter fixed on 9. I approached the DRT Kolkata for even preponing.
You are asking for an extension of the interim order?
Madam, that is disposed of matter. I had taken out a CAN application for adequate precaution, Milord. And Milord, I had mentioned the matter before the Milord Justice Mukherjee, principal bench. He said, I am office functor. You mentioned before the matter.
He's right.
So, Milord, I have 2-fold, Milord. I have also prepared 227 afresh and also taken out a Milord CAN. I leave it to your lordship, Milord. This is my circumstance.
Why will you require a fresh?
That is because of my abundant precaution, Milord. I intends to file with a liberty.
If no, I don't think that is
Madam,
necessary.
very good.
CAN.
Yes, CAN is there, Milord. CAN one.
Have you served?
Yes, Milord, can serve. Everything is served. A notice is given,
It will
Milord.
appear tomorrow. Sudeshna,
Grateful.
can the application and application can.
And together with the disposed of.
Yes, has to be.
Has.
Otherwise, I can.
Yes, ma'am. Grateful, Milord. I best grateful. He is giving the CAN to detail.
No one mentioning. Call the days list, please.
I beg to appeal on behalf of the respondent, Siliguri Jalpaiguri Development Authority.
He wants to withdraw. You don't want to proceed, right?
I am for the private response.
You don't want to proceed, right? Learned counsel for the petitioner submits that the petitioner does not intend to proceed with the matter further. Paragraph in view of the above, the application is dismissed for non-prosecution. I just said further.
Lordship.
1 and 2 same order.
1 and 2.
Next.
Grateful, Lordship.
Item number 3, Your Lordship, I am for the petitioner. The interim order was granted on 14th February, Your Lordship. And the affidavit has...
Responded like.
Yes.
Lordship, the affidavit has exchanged, but we are yet to file the reply. We only need 2 weeks time to...
Extension cannot be extended, Lordship, because it is the conditional.
We are ready for the hearing, Your Lordship. The reply is
It
yet...
was extended on the earlier date, right?
Yes, Your Lordship.
Why do you say that once it has been
No,
granted?
because their time limit is fixed to file the opposition, reply. They-
Yeah.
the
It
time-
says affidavit in reply may be filed prior to the adjourned date.
Yes, Your
Right,
Lordship.
Let there be a limited extension. Please be ready with your
Yeah,
reply.
we are ready with the... It's
Within a
only-
week? You'll
Only-
file within a week?
Within a week, yes, Your Lordship, within a week.
Learned
Lordship,
counsel?
there cannot be the further extension. This is the last.
Your Lordship, then recovery may be...
So we will be-
Then they will proceed with the
Finally-
recovery.
Counsel for the
My
petitioner
submission may be recorded.
seeks extension of time to use the affidavit in reply as sought. Paragraph, learned counsel for the... You are appearing for the
You need not. CGST authority.
for the respondents, opposes the said prayer and submits that affidavit in reply ought to have been filed within the time frame fixed by this court. Paragraph. Upon consideration of the submission made on behalf of the parties, comma,
Lordship,
The
respondent
petitioner is,
except four. Respondent number except four.
They are private respondents.
Yes. Four.
Your lordship, their affidavit in opposition is yet to be
you are for the union of it.
File can be- Yes, there is.
private respondents.
Oh.
Private respondents have not filed their
Do
affidavit
you
in
intend to
opposition.
file an opposition?
I will.
You will. Not
Then
that
we
till
will
date.
need time, your lordship.
Let them come back with a comprehensive reply in that case.
Yes.
Kindly, grant me 2 weeks time. Let me tell you.
ওটা করুন, okay. Learned counsel for the fourth respondent also seeks to use an affidavit in opposition in this matter. Stop, such affidavit in opposition be filed within 2 weeks, within 2 weeks from date. Stop, affidavit in reply, comma, if any, comma, to both the affidavits in opposition be filed by the petitioner within 1 week thereafter. After the opposition
Yes.
paragraph, the interim order granted earlier is extended till 2 weeks and 1 week takes us to 31st July. 31st July 2025 or until further orders, comma, whichever is earlier. Paragraph, the matter be placed before the next available circuit.
I'm grateful, your lordship. I'm grateful.
Next,
In item number 4, your
I wish to
lordship,
appear for the petitioner, lordship.
yes.
in item number 4, I am appearing on behalf of the respondent. Your lordship, kindly allow me 1 day accommodation. I have to,
Lordship, the
I have to-
adjudication order has been passed on 31st August 2023. From that day, it was pending. They haven't still date. They haven't uploaded the order in the portal, Lordship, and my right to appeal get hampered for that, right?
my lord, the matter is not so simple as because there is a provision under section 169 of the CGST Act, wherein service of notice has been categorically mentioned. But moreover, I have to obtain instruction from the department itself.
So this has
Yesterday
been
was the
continuing for the last 3 days, I believe. And it was
Yeah,
made not today, yesterday
Yes, yes,
also.
Lordship. Yes.
Yeah, my lord, just 1 day. Tomorrow
He's-
I
you know,
must appear
It has
physically.
been, no, I'm sorry, sir, this has been shifting by making not 2 days on 3 occasions that has been done. I will not grant any further time. The innocuous prayer is for uploading the order of the adjudicating authority.
My
Have
lord,
you
in
done
that
that?
case, kindly allow me tomorrow morning.
No further time will be granted. Have you uploaded the order in the
No,
website?
My lord, as per provision, kindly have a look into section 169. Uploading, if sometime uploading due
Yes.
to technical glitches, it was not possible to upload. If there is some technical glitches, in that case, section 169 will follow.
Technical
And there is
glitches
a
for how
several,
long, sir?
and there
The
was
Central Act.
several notification.
What is,
There are several notifications. I have to place those notifications together with the judgment. That's why I pray for 1 day accommodation so that I can place those judgment before your lordship by appearance physically. Kindly have a look into 169. One 169 service of notice.
yes, have you complied with any of these provisions?
Yes,
Any of these
yes.
days?
In their writ petition, it is categorically mentioned that they have received the physical copy by post, which was sent by post.
That is
They have
That is
mentioned.
sufficient. Then why are you asking for uploading?
But
Yes,
unless it's
but there is
uploaded,
no
Lordship,
question
we
of
cannot apply
uploading.
for the appeal.
No.
Where is that provision?
Lordship,
You have received a copy of the order, right?
yes, Lordship.
You
Yes,
can get a certified copy and you can apply for, you can prefer an appeal.
yes,
Why do you
yes.
require an uploaded copy only?
No, unless.
That is not necessary.
Lordship, kindly tell us the last annexure of the writ petition. Last annexure, Lordship.
No. Where is the provision that unless it is
Yes,
uploaded
yes.
to the server, you cannot prefer an appeal?
Yes,
Section
Lordship.
142.
We have quoted the provision 142.5 of CGST rules, which mandates that a summary order issued under section 73-74 must be uploaded on the GST portal. Unless it
Yes.
shows that disposed of or something, we
No,
don't file
no.
the appeal. Page, kindly comes to page number 70, Lordship. No records found. This is
Section 142.
140
142.
rule 142.5 of the GST rules.
Yes, but how does that debar you from preferring an
Yes.
appeal?
Yes, now kindly comes to page number 70 of my petition, Lordship, kindly see the portal
Page number?
70.
Why are you on the portal, sir? You
No,
have admittedly,
unless it shows the adjudication is disposed of, we can't file the appeal.
you
Because
have
at
a copy with you.
After
You have a physical copy which shows that it is disposed of.
it is,
It's disposed of,
Then-
but unless it is changed in the portal, it will my.
Where is that? Where is that rule or law? Show me.
Lordship, this is my instruction, unless it's shown in the portal, it.
Where do I find it? Where do I get it?
Page number
My-
70.
may I,
1717.
70.
my lord,
There is no records found in the portal.
Fine. That is
My-
admitted.
Yes,
Despite that, what is stopping you from preferring the appeal? You have a sir, copy of the order.
yes, but unless it shows the disposed of, my appeal will not be.
Your order doesn't show it is disposed of?
No, it says no records found.
Please show
My-
me the physical copy of the order.
Physical copy of the order I have received.
That doesn't show that it is disposed
Yes,
of?
it is
So
disposed.
why can't you
Yes.
prefer the appeal with that physical copy of order?
No, it will not be uploaded in the, unless the portal shows that it is disposed of, the appeal will not be uploaded.
Where is that stated?
Lordship, may I?
My
assist
lord,
because
may
I am
I-
also for the Union of India.
Yes.
My learned friend is here because the rule is being amended. So rule 108 gives the permission to file the manual.
yes, yes, on the basis of physical copy. On the basis
But
of
this
physical,
is,
moreover, my
I
lord,
mean,
moreover, my lord, there is a circular wherein it is categorically mentioned, the assessee or the registered petitioner can file appeal together with the physical copy. There is a circular. I can file this circular.
And there is the
And-
rules
And
also.
there is several judgment
Not
that
press
only
this.
for this ground, the
I
writ
dismiss.
petition will not be
I
entertained.
have to come back to, I should take some instructions from the client.
Again, what instruction?
Actually, let's take some instructions. So what is the, if you
And
get.
this is not rocket science that you
No,
can file an
no,
appeal
I
with the
understand.
copy.
No,
Right.
After a lapse of 2 years,
There is the-
Client takes a tour, I will take some
Rules
instructions.
is
very
also
after
there.
a lapse of 2 years,
Rules is also there, clearly mentioned. Because we are entertaining
So again,
so
not
many
today.
physical appeals.
Sir, you succeed.
yeah, my lord, that's why my humble submission. Kindly fix it day after tomorrow if
No,
possible,
no,
my
no,
lord.
no other,
Okay,
no.
all
day
right,
after.
all right. I can
Not
appear
today, I'll
physically.
request you to withdraw, otherwise I have to
Lordship.
dismiss this.
Lordship.
Yes, yes.
Next,
I shall submit those circular as well as judgment.
not necessary,
Yeah.
sir, not necessary.
All right. Grateful.
My lord, in this case, I am
Sorry,
for the
sorry.
petitioner
Yes.
and may I,
We are-
your lordship,
Respondent number 1 to 4 and led by Mr. DSJ online.
and this is the affidavit of service.
Online.
He's appearing, yes.
May I proceed?
Have you served the bank?
Yes, my lord.
The bank, there's a private respondent also. Friday.
आज क्या है?
Have you served 8? Kaushik
Everyone,
Kumar Bose?
everyone, my lord, everyone. Uh, My lord,
Give me a minute, please.
Hmm.
Where is the service on 8? Please show me.
service on 8. 8 is a husband. My lord, we have served him, but maybe he has refused or something, but the notice was also sent to him also.
Others are represented, right?
Hmm.
Only I do not find his representation. You
My
not
lord-
even annex the track report because it is not served. Right?
Which one?
Where's the track report
Respondent
of,
number 8.
Yes, the private respondent.
My lord, he is not the answering respondent. He is not
Whatever.
important here.
You have impleted an unimportant party also, right?
Here the main,
So
main,
once you implete someone, you have to
Yes, my
serve
lord.
whether he is important or not.
my lord, he will not receive only, my lord. I know that.
So do you want to delete his name from here, from the cost title? Can you continue without his name? You cannot?
No. No,
And
Yes, yeah,
right? So you need to serve.
my lord, may I proceed the contents of the facts of the case, my lord? It's very interesting, my lord. Here the main important party are
I do
the
not find any
respondent
matter boring,
authorities, my lord.
believe me.
My lord, the respondent authorities are the main person who can give the relief.
Maybe, but once
yes,
you've
my-
impleted someone, whether the
Yes, my
person
lord.
is important or
Yes, my lord.
unimportant,
Yes,
you
my-
need to serve, right?
Yes, my,
Please serve and come back.
yes, my lord.
Since service upon affidavit of service. Since service upon the 8th respondent is not complete, comma, let the matter stand over till, when can you come back? Next week?
Friday.
This Friday you can come back?
आज के-
Today is
Wednesday.
Wednesday, can you come back on Friday?
Then keep on
Next
Monday.
week?
Yes, yes, my lord.
Tuesday, right?
Hmm.
That is 8th July.
Great.
Next,
Grateful, my lord. 8th of July.
Lordship, for item number 6, I'm appearing on behalf of the SMC. Led by Mr. Vijay Shankar Das. Lordship, for some medical emergency, he couldn't be able to appear before the court. Kindly
when can you
keep the
come back?
matter next week, Lordship.
Next week?
Next week. Monday,
Monday, Tuesday is too full.
any day on next week.
Wednesday,
Lordship.
9th,
We have to pitch.
9th.
Mine.
Learned Council for the. You are appearing for?
SMC, Siliguri Municipal Corporation.
Have you served the others?
I for the state.
The service has been affected on
The private
most of the
respondents?
parties. Most of the parties have been served, but
Most,
other,
not all.
not all.
So please serve and.
And
There are several private respondents.
lots.
I'll fix it on 9th. Please serve and come back.
So I have made several attempts to serve them. Actually, either it is returning with the endorsement, address is not found, or shifted without any instruction with that
You have to
endorsement.
get the address.
And those
You are appearing?
Yes, ma'am.
private respondents.
Who are they?
Yes.
Please, yes.
Some are represented by her.
Oh, so let me fix it on 9th.
So
Please find out who all are represented.
appearing.
Please find, I think you are appearing for all of them in that
No,
case.
not all of
The
them.
private respondents.
No, not for
No,
all.
because even she's
But
appearing.
I will inform.
Please do that.
We are appearing.
So please try and serve the others.
Lost.
Right.
Great.
Since service upon all the respondents is not complete, comma, let the matter stand over till 9th July 2025.
Great.
Next.
My lords, I appear for the petition.
Yes.
Item number 7, is it item
Seven,
number?
yes.
Yes, I am appearing on behalf of the CGST department. My lord, some more instruction is required. Kindly fix it tomorrow. It is also. I will
Very well.
appear physically.
Not
and-
today. Very well. Not today.
Not today. That's
Next.
Lordship, I'm praying for not today. Learned Senior Mr. Bodhan Bhattacharya.
Lordship, in the earlier occasion,
What's
they have
matter,
paid
Lord?
3 times. Not the circuit.
Not
I'll
today.
remember this.
And-
Be ready tomorrow.
No, it is specially mentioned also in the last order.
Not today only. Please be ready tomorrow, right? Next.
Deeply.
For the state.
Lordship, I'm appearing on behalf of the petitioner. Lordship, not today. Praying for not.
Not today.
Lordship. 10.
Yes, you are the petitioner.
It's a CGST matter, my lord. My lord, I've served my lord. It's active of service.
You are appearing, sir?
Yes. এটা 10 নম্বর এটাই?
হ্যাঁ, 10 নম্বর এটাই।
আমার করে দাও।
Affidavit of service.
Only the CGST is the respondent?
Only CGST.
Lordship, there is alternative remedy to file the appeal.
Thereafter, he can say.
No, actually, this is the adjudication order. He come against the adjudication order. So there is 107 is alternative remedy is
Sir,
here.
then thereafter he can.
Because there is the order of 700 pages.
He's on maintainability, so he'll have the first right of audience.
Mine.
So that's
on
why I am
fine.
just, because the adjudication order, Lordship can find it's
Oh, this is
around-
against the adjudication order?
Yes,
Yes.
my lord. Yes, my lord.
So appeal is there,
My lord.
107, and the
Let
adjudication.
her respond.
Right.
My lord, I'm aggrieved by the notice which has been given to me under section 74. Now, my lord, if your lordship comes to page number 40, my lord, as because he's talking of the maintenance, right?
Yes, yes.
So I'm stressing on that.
Page number 40.
40,
yes.
my lord.
Yes.
So, my lord, if your lordship sees, my lord, the notice has been specifically given against Rajesh Kumar Sadda, PAN AL. So he is being given this notice in his personal capacity. So my first question is that whether 74 notice can be given against a person in his personal capacity. Not only that, my lord, there are 8 firms, my lord. Your lordship sees, my lord, there are 8 firms where Rajesh Kumar Sadda happens to be a proprietor of Krishna Trader, my lord. What? My lord, page number
So
40.
you still have a right of appeal?
No, I don't have, my lord. I don't have. I'm also challenging the intimation notice because it's bad in law, my lord. This intimation notice is a compilation of all the years, my lord, which cannot be given, my lord. And compounded notice, which is said, my lord, I have a judgment to that score, my lord. And not only that, my lord, a 74 notice along with 200
If the notice itself
100.
is bad in law,
Yes.
according to you,
my lord.
the appellate authority will decide.
No, my lord, because my lord, and not only that, my lord, they have compiled the whole. What they have done, my lord? They have compiled the amount of all the 8 firms.
Maybe you're not challenging the propriety, the jurisdiction, nothing. You're only on
My lord, I can
the
set aside-
legality
my lord, I can
of
set aside
the,
the show cause notice if it is bad in law, my lord, prima facie.
that can be done by the appellate authority, madam. not
My
by
lord,
this court.
there is a 40 crore rupees
No, that.
penalty. Wait 1 minute, please. 40 crore rupees penalty which has been given against me, my lord.
Have
Most
you crossed
illegally, my lord.
Have you crossed the limitation period?
Yes, my lord, I've crossed that. Not only I have, after the order has been given, soon thereafter I filed the writ, my lord. Soon I filed because I do not, because my firm, against my firm, they have already.
So I'll condone the limitation. You need to go before
My
the
lord, my
proper
lord,
forum.
my lord, kindly, my lord. But if I'm able to satisfy your lordship, my lord, kindly let me submit, my lord. My lord, what has happened in this
Let
case?
us come to 107 first.
107. Yes, yes, yes. सब बोलेंगे ना. My lord, 107.
Yes.
What has happened, my lord? Over here, my lord, I am already a registered entity who has been made a party in this case, my lord. And not only my firm has been given the notice, my lord, I on my personal capacity have been given the notice which is bad in law. Because 74 clearly states that a registered person has to be given a notice. And on a personal capacity, a 74 notice cannot be given. To that score, my lord, if your lordship kindly comes to 74 once, my lord.
Yes.
My lord, it says, my lord, where it appears to the proper officer that any tax has not been paid or short paid or erroneously refunded, or where input tax credit has been wrongly availed, utilized by reason of fraud, willful misstatement or suppression of fact to evade tax, he shall serve notice on the person chargeable with tax. So I am chargeable with tax when I am paying the tax. I am claiming the ITC on behalf of Krishna Traders. Krishna Traders has already been made a party to this case, my lord. They in this, if your lordship sees
In addition, you've been made a party in your personal capacity. That's
personal
what you said,
capacity,
right?
which cannot be done under 74, my lord. Not only that, my lord, they have given me a notice of several years, my lord, and multiple years notice. And what they have done, my lord, very interesting, my lord.
Even if I hold that entire order is illegal, the notice is illegal,
I'm just seeking that a fresh intimation notice to be
but
given.
still the appellate authority will deal with this.
My lord, no, my lord. I'll show the judgment to that score, my lord.
Please show me.
My lord, I have a Supreme Court judgment to that score, my lord. Today I did not have that. But I will bring, my lord, if your lordship keeps this matter on any
Because prima facie, I find this court cannot deal with
my lord,
this.
I will satisfy
Yes,
the
it is
lordship.
the similar view in the earlier,
No.
in earlier bench also.
My lord,
Earlier bench is also disposing this
I
matter
have a judgment.
on the same ground.
Yes, my lord, I have a judgment of Kerala High Court, another judgment
Please
of
show me the
Kerala High
Supreme
Court.
Court judge.
My lord,
My lord,
107 may kindly be seen once,
I'll give the Supreme
Tomorrow?
Court judgment. Tomorrow. sir.
because we are on the appeal.
Not
So
today.
107 may kindly be seen.
Not today. I've seen 107.
Yes.
Not today.
My lord, I'll
My-
do that. I'm grateful, my lord.
So our appearance may be noted there also.
ওদিকে এক জায়গা ঢুকেছে?
What's if our appearance may be noted?
Yes, yes, of course. Oh, it's just not today, so appearance cannot be noted, sir, I'm sorry. Come back tomorrow.
My lords, I appear for the petition.
Yes,
My lords, here I'm challenging the appeal. I've come after appeal since there is no tribunal. There's a GST case. My lords, I am in the adjudication order. My refund application was rejected.
have you served?
Yes, my lords. Miss Reema is appearing. She was, yes, she's come. My lords, briefly, I'll tell you the facts and I'll take you through the brief. My lords, during the period April 2018 to July 2018, due to some confusion with regards to place of supply, instead of paying CGST and SGST, I paid IGST for the period of 4 months. Subsequently, a show cause notice was issued to me. Against that show cause notice, I accepted that and I made the payment. Now, at the time of making the payment, in the challan, the year I selected, instead of 1819, I selected 1920. Subsequently, an order was passed in which it was accepted that, all right, for the same year, it was accepted. After that, I filed a refund under section 77, which gives me a statutory right to claim refund for taxes paid under the wrong heads. My point was that since I have paid wrongly the amount of GST in 1819, kindly give me the refund. This refund was rejected solely on the premise that at the time of that challan payment, you have entered 1819 instead of 1920 instead of 1819. However, my lords, that challan was ultimately culminated into an order subsequently. So, my lords, it is
Showing completely. payment for 1890?
Yes, my lords. The order is also there for 1819. So in 1 year, they are accepting my payment and the other year, they are denying me the fund, saying that that challan is wrong. I'll take you through the documents, my lords. I'm coming after appeal.
You don't need to come back with an affidavit, right? Opposition.
My lord, the thing is that they have to file it a rectification. There is an error. He admits to that.
No,
My lord, then.
what I am submitting, my lords, that DRC challan which I had made payment. After that, there was a culmination into an adjudication order where they themselves accepted that for the same year. She can correct me if I'm wrong. Since that, after that challan, the order was also passed for that year. Now, why do I need to file a rectification? They have already accepted that payment. And my lords, in the refund application, we have to submit a
Please show
statement.
me that order.
Yes, my lords, I'll show.
Application.
First, I'll show you, my lords, the show cause notice, which is 27, page number 27. This was the first show cause notice, which I received. Page number 29 is the operative part.
This
Then,
is
my lords,
73 notice which has been received.
yes.
Page number 73.
No, no, no.
Oh, 73 notice.
Page number 29 and 30 is the show cause notice, where they where they raise this issue. In page number 32, my lords, I file my reply. 32 and 33.
Notice that this is 1819.
Yes, my lords, this is 1819. Here they say that ITC availed in excess. First one, my lords, tax short paid on outward supply. Central tax 6,18,865 and 6 lakh. This was the amount which they ought to, they were asking from me. Now, my lords, come to page number 32. Observation 1. The above short tax paid is due to equivalent excess amount paid in IGST. Therefore, we have paid the CGST and SGST each through DRC 03 dated so and so. We further apply for the refund. At page number 34 is my challan, my lords.
This is your reply.
Yes. I am saying that I've made this payment now. And I've annexed the challan. My lords, take page number 34. 34 is the challan. And the bottom, my lords, will find the reasons. Reasons is that, my lords, IGST paid instead of CGST and SGST. Therefore, CGST and SGST is being paid now.
IGST will come back to, like,
Yes.
will be refund.
And next page, my lords, here I made an error. In the year, my lords, it is selected 1920 financial year.
Where is that stated?
Page number 34. This is the challan which was wrongly entered the year, my lords. Where, yes. Then, my lords, come to page number 36. This was the dropping of order for 1819.
But you made the payment in 1920,
37 to 39 is the reasoned order.
This proceeding was dropped, the
Yes.
non-refund proceeding.
Yes,
Correct.
37 to
70
39. Well, let's kindly take 39. They have also recorded that DRC payment which was done at page number 39.
Yeah, this is clearance.
Yes.
Clearance of
Then,
outstanding.
Milots, I apply for refund at page number 40. 41 was my
But what
refund.
she's pointing out is this is all for 1920.
Milots, kindly see the order which was passed.
Yes, I want to see that. Yes,
Page number 36.
that should be clear.
36 is financial year 1819, tax period 1819. So after that challan, they had cleared my, for 1819, they had dropped my demand without any rectification.
So this challan ought to have been rectified where you've stated 1920.
Absolutely.
My lords, that was after that, they have already accepted this. And that is why they record this in the order. At page number 39, my lords will find the DRC is also recorded. So with respect to 1819, they had cleared my demand.
Please come to page 38.
Yes, my lords.
It doesn't say either 1819 or 1920.
My lords, the first page says the period. The first page, period 1819. Because the proceedings was for 1819, my lords. It cannot be for 1920.
1920, there was no dispute at all.
No, no.
Let me hear.
Then, my lords, my refund, I'll show how it was rejected. Page number 40, 41 was my refund. After this order, I applied for refund, asking back the IGST amount which was paid. In 42 was the statement which was filed, my lords. 42 to 44. This is a statutory statement where I have to show the invoice-wise transaction, which was subsequently held to be IGST or CGST. Ultimately, my lords, in page number 49 and 47 and 48 is the date of order, my lords. $58, my lords. I'm sorry. 58 is the operative part of the order. 61, 62, my lords, which was the final order passed in my case.
Page?
My lord, 61 and 62. They issue me a show cause notice. Thereafter, I filed a reply and the final order was passed in 61 and 62. 62, last part is the operative part.
They have again referred to the financial year in rejecting
Yes.
this.
So, my lords, I am not claiming refund of the IG. I am claiming refund of the IGST amount, which was paid by me in the year 2018.
Have you applied for a rectification of the year in the challan?
In the appeal, I requested them to allow me to rectify the challan. If required, they rejected my request. At page number 78 is the operative part of the appellate authority. But, my lords, my contention is that I do not need to file a rectification. Why I say so? Because, my lords, for 1819, it is their order after the challan date, because the challan has been acted upon by the department. It has culminated into an order. So they have accepted my payment for 1819. To today, while granting refund, my lords, they cannot deny me refund, saying that you had made a wrong entry in the challan, that field entry is wrong. Same position was reiterated by the appellate authority. Page number 77 and 78 is the operative part. It starts from 76. 78, my lords, is the operative part, last 4 paragraphs.
Yes, I want to do that.
That's the only
Yeah,
reason.
from-
or
Yes,
the only
yes,
ground
yes,
of
that is the
rejection.
only
The
case.
rectification is required to be done. That is,
That's too technical, madam.
my lord, the rectification has to be
Everywhere
done.
else you have admitted
Yes.
that
My lord, I totally agree, my lord. Whatever your lordship says, my lord, I totally agree. But there is a bar under section 37 which says that if there is, my lord, if there is a discovery of error, the rectification is required to be done by them, and that has to be done within the period of limitation. And that issue is pending before the Honorable Supreme Court, my lord. So that is the reason, my lord, even if the rectification has not been allowed, my lord, first, whether it is barred by limitation, that's why it was not allowed, my lord. So
that is
without,
not recorded.
but that is not
Order doesn't
recorded, but he
This
says
coming
the
from the
rectification
bar.
is allowed.
So I don't think you can take that point.
This is coming from the bar.
My lord, the thing is that if he wants to do the
Let us see
rectification,
what 37 says.
yes,
37 is not related, my lords. That is related
That's
to
right.
outward supplies. GSTR 1 returns. This has nothing to do with this case.
37(3).
37 relates to furnishing details of outward supplies.
Yes, they were given a 73 notice for that. Because of that,
No, no.
yes,
And that was dropped. So
that
That was dropped. Yes, my lords.
That
That is
was
my
dropped.
case.
and that is why he has seeked for the refund, my lord.
I am seeking
But the
refund.
problem which the authority is facing is in the year. My lord, he has mentioned a wrong year in the making of the payment.
I'll solve the problem of it.
My lord, the thing is that without a rectification, the department is facing problem, my lord. That is only the problem.
With the direction from the High Court, the department will not further face.
No,
the
that
problem.
the department will do.
So that's what I'm
That
saying.
the
I'll help
department
you. I'll help you out. Heard learned counsels for the parties. Paragraph. The petitioner is agreed by the
Rejection of refund application.
order passed by the appellate authority under section 107 of the West Bengal Goods and Services Tax Act 2017. Comma herein after referred to as the Act of 2017. Turning down 2017. Passed on 20th January 2025. Turning down his prayer for refund of the IGST tax deposited by him, comma, in confirmation of the order of the adjudicating authority. Paragraph learned counsel for the petitioner submits that for the tax period April 2018 to March 2019, comma, the petitioner paid IGST to the tune of rupees 601865, right? 601865.
Well, it's into two actually. That will be into two. Total amount would be, my lords, 11 lakh.
To the tune of
12 lakh 1,460.
to the tune of rupees at a we figure to 1 to
12 lakh 1,460.
instead of instead of CGST and WBGST. Proceeding under section 73 was initiated, 73 of the Act was initiated against him. The petitioner deposited the said amount as CGST and WBGST, following which WBGST for the said period, following which the proceeding was dropped. The petitioner sought refund of the amount deposited under IGST since the said amount was already paid by the petitioner under CGST and WBGST. The adjudicating authority turned down the prayer of the petitioner solely on the ground that in the challan, the period of tax has been recorded as
1920, no?
2019, 1920, right?
1920.
19-2020 instead of 2018/2019.
Right.
The appellate authority has also affirmed the said observation and rejected the appeal. Learned paragraph. Learned counsel for the respondents submits that the petitioner ought to have filed a rectification application under section 37 of the Act for seeking rectification of the
37,
wrong
39.
entry. Yes,
It can be 37 and 39 also.
37/39. Seeking rectification of the wrong entry in the challan. Paragraph. I have considered the material on record. The authority, comma, in accepting the payments of the petitioner under CGST and WBGST and dropping the proceeding under section 73 of the Act, comma, has in authority has in fact accepted payment made by the petitioner under the payment made by the petitioner for the period 2018-2019. It is also not in dispute that the petitioner paid the said amount under IGST for the same period, comma, that is 2018-2019. Where is the challan? The document which stands in the way is the challan dated 2nd March 2024, which shows that which refers to the tax period as 2019-2020. So, paragraph, in my considered view, comma, since the authority has accepted payment of tax by the petitioner for the period 2018-2019 under CGST and WBGST, and also the fact that the said amount was wrongly deposited by the petitioner under IGST, comma, the wrong recording in the challan of the tax period as 2019-2020 should not stand in the way of refund of the excess amount doubly paid, DOUBLY, paid by the petitioner under the said head. Head, HEAD. There being no dues from the petitioner, there being admittedly no dues from the petitioner, up to up to July 2024, that is the recording, right? Up to July 2024, comma. The petitioner cannot be deprived of refund of the excess amount deposited by him for the year 2018-19. Paragraph, in view of the above, comma, the
Will be directed.
who will refund?
Huh? Yes. Whom you have given the application?
To
I think,
Senior Joint Commissioner.
it is given to, no, it is the appellate authority to whom you have given the refund application. One. Appeal হয়েছে।
No, appeal is
Oh,
just
some,
affirmation,
yeah.
but it will be returned by one in that
One,
case.
yes, ma'am.
In view of the above, comma, the first respondent is directed to refund the amount of rupees 12 lakhs deposited by the petitioner as IGST within 2 weeks,
It will take some time, madam. 4 weeks, you
4
kindly make
weeks.
it 4 weeks.
within 4 weeks from the date of communication of the order.
I'm grateful.
My lord's affidavit.
With the affidavit of service,
Deeply grateful.
as this is be disposed of, there shall have been order is crossed since no affidavit is invited. That is it. Next. Yes.
This is the affidavit of service. I have served all the parties.
State? It's only the state, right?
Lordship.
Who is appearing for the state? No one. So the state has no objection. No one for the state.
Even Forest Department is also a party
Shah?
of this.
Not, not today.
It's a very.
Have you served the forest department?
Yes, I did.
Not today,
Everybody,
let Ms. Shah come back with instructions. Next. 13,
Ladyship, I am
served.
served, everybody.
State. What is wrong?
No, no, no.
No one. No one for the state in 13. Not today.
Let's.
My lord, 49 for the petitioner, my lord.
Police for-
I am for the petitioner, my lord, item number 14, my lord.
Yes, yes.
My lord, matter about, my lord, non-issuance of timetable of my vehicle, as well as, my lord, cancel my permit of my vehicle, my lord. My lord, kindly consider, my lord, page 21, my lord.
Group
is-
7, of course, today I'm dealing with it.
Page 21, my lord, kindly consider once. That is offer letter, my lord, issued by the respondent number 2, RTA Kuch Bihar.
You are appearing for,
My lord, that is the offer letter, my lord, page 21, dated 6/11/2024, issued by the respondent number 2, my lord, to the petitioner. My lord, as per resolution of RTA board meeting dated 23rd February
have you served the
2024.
respondents?
My lord, yes, my lord, my junior is there, my lord. Serve upon all the respondents, my lord. My lord, page
Yes,
21,
yes.
offer letter issued by the respondent number 2, RTA Kuch Bihar, to the petitioner, my lord. According to that, my lord, thereafter, my lord, page
Page
number, my lord,
21 is a letter to the RTO by one Ratan Chakladar, Bus Motor Owners Association.
my lord, secretary, my lord, from secretary, Regional Transport Authority,
No.
Kuch Bihar to Subroto Kundu, page 21, my lord. Page
No, no.
21,
Paginations are not correct.
my lord, after the affidavit page, my lord, page 20, my lord, then page 21, my lord. Offer letter, my lord.
Affidavit is at page 13, 1-3.
Yes, ma'am.
Page 13, my lord. My lord, thereafter, my lord, after affidavit, one page after, my lord, it is offer letter, my lord.
This is the resolution of the court.
Resolution of the board, my lord.
Then is
Exact,
the
my lord.
NOC. This way I cannot take up matters. Please do the proper paginations.
My lord, until not today, my lord.
Your offer, I do not find the offer letter here.
My lord, I'm paying for not today, my lord.
Oh, offer letter is page 16.
16, my lord.
Paginations should be correct, sir.
My lord, clerk is mistake, my lord. My lord, as per resolution of RTA board meeting dated 23rd February 2024 and subsequent issuance of NOC by the RTA Alipur Duar via memo number such and such dated 25/10/2024. And on that basis, my lord, the RTA Kuch Bihar issued permit to the petitioner, and on that basis, my lord, on issued the permit, my lord, on 19th May 2025.
Yes.
My lord, my permit has annexed with this writ application, my lord. There should be paginess and some discrepancies, my lord. On 19th May 2025, issued the permit to the petitioner, my lord. That is Mathabhanga bus stand to Joygaon via Kuch Bihar, Sonapur, Mathura Bajar, Hasimara. That is the
Page?
permit.
Where are you?
In that permit, my lord, kindly consider, my lord, bottom portion of the permit, number of daily single
No,
trips
I do
allowed.
not know. Where is the permit?
Provisional timetable is page 22-1.
Permit, my lord. Permit.
The provisional
Please
timetable.
come back tomorrow, sir. This way
My
I
lord,
can.
my lord,
take
my lord,
matters.
oblige your lordship, my lord. Oblige your lordship.
Not today.
Next time again.
Please check the page numbers.
Oblige your lordship, my lord, obviously, my lord.
Next. Yes.
15 Millard, I beg to appear for the petitioner.
Lordship, I am for the municipality. We have asked for the report, Your Lordship, but it's yet to come. Praying for next week,
Well,
any day of next week.
It's a very simple matter, Millard. The petitioner is a woman, Millard. She was granted a stall for certain practical difficulties, Millard, which is not curable, Millard. She is unable to run her business. We have only made a prayer that instead of stall number 9, kindly grant me 1, 2, 3, whichever
The
is
prayer
vacant.
has not been considered.
Prayer has not been considered, Milord. I am praying for Milord. Probably if Milord considers Milord direction upon them, Milord, to kindly make arrangements for relocation. But
That direction cannot be given by this court. Please
Milord,
consider the prayer.
let them come back with the report. If it is feasible, let them see, let them file a report if it is feasible. Then they will consider, Milord, I'll at least Milord move a step ahead.
Come back.
Next week, Lordship, in any day.
Learned Counsel for the municipality
Municipal.
needs to submit a report in this matter. Paragraph, let the matter appear under the same heading on 10 July. Short matter.
I have no difficulty.
Give me a minute, please. Determination has changed.
Yes, Milord, I saw.
Oh, yes.
I think Milord, it's from tomorrow.
Yes,
Ju-
this is from
Just-
3rd
Justice
July.
Omnad and Rai would be taking up all the
Creditors, anticipatory bail. And NDPS FOXO bails. Let there be dates, the bench will deal with, the appropriate bench will deal with.
But it's effective from tomorrow probably.
So today I am calling for a report.
Yes, yes. Today
So
there's
if
no.
I do it today, it is done.
Yes, yes.
Otherwise,
How far we can go today?
the appropriate bench will do it.
Yes, yes.
Because
No,
from
it's not
2nd,
difficult.
if I'll take up criminal matters today.
It has to be. There are other matters.
Yes, because anticipatory bails and all are pending.
Yes. Grateful.
And date, fuck.
May I please, your ladyship? Ladyship, again, the state of West Bengal is the first party here, first respondent. I don't know whether they will appear or not.
State. No one.
Every matter I have served.
So state will not oppose.
State is, I think, supporting.
Whether you'll oppose.
Whether they have served or not.
No,
He has an affidavit of service, I'm sure.
State of West Bengal.
You have your affidavit of service.
Yes, yes, ladyship, I have.
Official only.
No, official deal.
One of the, my direct bid was, I think number 330.
Lordship, I agree, but I have sent it to state of West Bengal directly.
No, that's.
There has to be a service on GP's office.
Then ladyship may.
In this matter also, please do that.
Yes, yes, same.
Not today.
Let's.
Because I'll not be dealing with these matters from tomorrow, so.
That is the reason we're stating from it.
The client is directly doing all these things. These are legal aid matters, so we cannot do everything, lordship.
No, but it's the easiest way.
They're staying in Kuch Bihar, they generally say.
Instead of sending it there, it's the easiest way is GP's office.
Actually, it's easier for them to post from their place, that's the thing.
Anyway, by today, serve the GP's
Let's.
office.
Let's.
Next.
May it please, Milord. Milord, in item number 17, I appeared for the petitioner, Milord. I seek your lordship's leave to appear virtually, Milord.
Yes, yes.
Your
Milord, there's
lordship,
nothing
your
in this
lordship,
matter, Milord. It
I am
has become
appearing-
infructuous, Milord. So,
Your
Milord,
lordship, I am appearing on behalf of the respondent. Your lordship, I have a short prayer. Just yesterday, I have received the petition. I have
I
to
think-
take instruction.
I think the
No, it has
petitioner
become
wants to-
infructuous, Milord.
wants to withdraw. He says it has become infructuous.
Milord,
Oh,
No
not
need further
withdraw, Milord.
instructions.
Milord, not withdraw, Milord. I have challenged the repetitive issuance of summons, Milord. Now, what the GST department has done, they have already issued the DRC 01A. So the summons part is over, Milord. In that view, Milord, the cause of action does not survive in this petition, Milord.
Learned counsel for the petitioner submits that the cause of action of the present writ petition does not survive What has been done by the GST, you've said?
My lord, they've issued the DRC 01A, that is the intimation of the tax payable, my lord.
Oh.
So
That
I've
means it
already
has been-
submitted my,
It has been
Yes, ma'am.
adjudicated.
that is the first step of adjudication, my lord. So that they have already initiated that.
Moreover, earlier occasion also same type of writ petition was filed. So I have to take some
Yes.
instruction. That's why my humble submission, let the matter be fixed tomorrow.
Infructuous.
My lord, I am not
Infructuous.
pressing for anything, my lord.
Yes. Survive and the petition has become infructuous. Through the affidavit of service. Paragraph in view of the above, comma, the writ petition is disposed of as, is dismissed as infructuous.
My lord, may I
My-
pray for a short
my-
direction, my lord? Can the respondents be directed to act in accordance with law?
No. You have prayed for withdrawal.
This is like directing someone not to murder.
Yes.
They cannot
am
act
grateful.
illegally. They have to act in accordance with law, right?
But I'm grateful. I'm
Next.
grateful.
My lord, my name kindly may be recorded.
Yes, of
Ratan
course.
Bonik. Ratan Bonik for CGST.
Please give it in the chat box. It will be recorded.
Right.
I'm grateful, my lord.
Grateful, my lord.
Yes.
My lord, this was the matter, my lord, which yesterday I had placed briefly. Since the government leader was pending, my lord, I prayed for a day's accommodation. My lord, this is against, my lord, an appellate order.
The Union of India is also a party.
Union of India is a party,
No,
my
I
lord.
statement.
My lord, Union of India is a party, my lord, because CBIC's notification is under challenge.
Who is appearing for the Union of
My lord,
India?
they're served. They're
Lordship,
served.
I am appearing for Union of India.
Mr.
My lord,
Majumdar is
I'm-
appearing.
Oh,
My lord, the
Mr.
matter is
Majumdar,
pending
sir.
before the
Wait.
Honorable Supreme
Today.
Court. My lord. This is the order.
No,
Yes,
no.
I have indicated before your lordship on the
Pura
last
dhore
occasion.
My lord, may I hand
That
over?
my lord,
The same issue?
same issue. My lord, the several high courts, my lord, have expressed diverse opinions.
That's
168 extension, yes.
yes.
Matter has gone.
Yes, now, my lord, what I will pray today, my lord, subject to, my lord, correction, this cannot be heard without affidavits. Let affidavits be filed. Now, my lord, only one
Before
prayer,
that, let this be disposed of, considered by the Supreme Court.
my lord,
Before that, I don't think it's necessary to call for affidavits also.
my lord, in that event, my lord, I'll make, my lord, one prayer. My lord, since the tribunal is not functional, we are before your lordships after the appellate order. Now, my lord, before the tribunal, upon deposit of 10% of the demand, there is an automatic stay. My lord, I'll make the same prayer. I'm ready to deposit 10% of the demand. My lord, in view of, my lord, pendency of this, kindly, my lord, let the demand be stayed for the time being. I'm ready to deposit 10%. Well, had the tribunal been operational, my lord, it was a statutory right. And my lord, this is, my lord, the Telangana's judgment, Telangana High Court, my lord, which travelled up to the Supreme Court, the batch of petitions from Telangana High Court. All the diverse opinions expressed by Guwahati, Patna and Allahabad has been recorded. That's why, my lord, I have placed that.
Affidavit was called for, my lord, then the subsequent date is adjourned. No effective order was passed by the Honorable Supreme Court as of now.
Even with regard to the interim relief.
Yes,
That
that not,
also will be considered on the
Yes,
next
yes.
occasion. That is recorded.
yes.
My lord, that is in the Supreme Court. But my lord, my issue is squarely, my lord, connected with the outcome of that litigation pending before the Supreme Court.
So when the Supreme Court is in session of the matter, why the authority will definitely not take steps on that? Why do you require an interim order?
My lord, I'm ready to deposit the 10% amount. My lord, let them, my lord, Mr. Chaudhary assures that there will be no coercive measure with regard to the
Usual, my lord,
demand.
as of now, we have not initiated any
No,
coercive
since
step.
the matter is being
Yes,
dealt
yes.
with by the Honorable Supreme
Exactly.
Court.
My lord, just
think
record,
coercive
my
measures
lord,
also.
record just one line that since it is in session before the Supreme Court, it is expected that they will not. My lord, that will suffice.
No problem.
That will suffice.
No problem.
Grateful, my lord.
Third learned counsels for the parties.
Lord, affidavit of service.
Show the affidavit of service.
Hmm.
It is submitted on behalf of both the parties that the issue which calls for consideration in the present matter is pending consideration before the Honorable Supreme Court. Paragraph. In view of the above comma, let the matter go out of list for the time being. Paragraph, since the Honorable Supreme Court is in session of the matter, comma, it is expected that no coercive steps shall be taken by the authorities against the petitioner in connection with the present matter.
Grateful, extremely grateful. Extremely grateful.
Till awaiting observation by the Honorable Supreme.
Grateful, extremely grateful.
You can take this back if you want.
Yes, yes.
Yes, my lord.
Judgment. Like,
Next.
Supreme Court at first time.
Supreme Court, I mean, you keep it, I have a copy.
Thank you.
Yes,
19th, my lord, in this matter, I am for all the respondents. my lord.
petitioner, you are appearing? Yes.
The University of North Bengal, college, and the state is also my jury.
This writ application is relating to the illegally cancelling a studentship of a student, my lord. My lord, in the my lord, the petitioner is a bona fide student of the respondent college, and when she appeared in her 5th semester examination, that is my annexure P7, page number 26, my lord, she got back in all subjects, and she was supposed to reappear again in the examination. My lord, she appeared in the 5th semester examination in the next year, the next session again, and she qualified in all the subjects except for one subject, that is the constitutional law 2. My lord, then what happened? She was allowed to sit in the next semester, and she was supposed to give her supplementary paper. And when she was in the 6th semester, she didn't appear for she was not notified to appear for the examination that she has got back in. As per next, she also passed in.
She was not notified about the supplementaries.
She had to appear in the 6th semester or in the 7th semester. When she inquired in the university, in the authorities, she was not informed properly. She was said said that she can appear in the examination till the end of the semester anytime she wants, in any semester she wants. What happened after that? She was allowed to appear in the 7th semester. Now, when she passed the 7th semester, and now she is supposed
Without
to
the
appear
supplementary.
without the supplementary paper. Now she is supposed to appear in the 8th semester examination, my lord. When she is trying to fill up her registration in the online portal of North Bengal University, it is showing as, my lord, the page number 33, that is the annexure P12 of my application. My lord, when she is trying to fill up the form to appear in the 8th semester, it is appearing as, check the registration number you have entered. Either the registration number is incorrect or you are not eligible.
You are at page 33. Oh, check. Oh, yes.
Yes. After that, she made a representation in the court, in the college to the assistant controller of examination through the principal in charge, my lord. Now, what happened is that
5th and 6th supplementary. So there were two back papers.
there were two back papers.
One in the 5th semester, one
One
in
in
the
the
6th
5th semester, one in the 6th semester. Now, my lord, if let us consider, if she did not appear in the 6th semester, she appeared in the 6th semester, and if, let us consider, she is supposed to get 3 chances to appear for the examination, and after that, she will get a special chance of studentship revival chance. That was not provided to her. Moreover, she was if my lord will come to page number 27.
Has this been considered by the authority?
No, my lord.
The application?
No, my lord. It has not yet been considered. The examination is going to commence from on the 8th or 9th of this July.
When did you
The
file the
entire
application?
situation, my lord. My lord, I would like to point out one more thing. My lord, if my lord comes to page number 27,
Yes.
if my lord will come to page number 27, you can see that this is the mark sheet that was provided in the online, and she downloaded it from online portal of the university, my lord. Here it has been stated, constitutional law, she got 21 marks in theory paper. My lord will 27. If my lord will come to the next page, that is the mark sheet that has been provided to her, the hard copy that the college provides generally. My lord will see that in the constitutional law paper, she stated there as absent.
Yes.
The illegality, the irregularities by the university, my lord, that I would like to point out before the portal. Moreover, my lord, I would like to point one more thing.
Have you approached the authority on this issue?
We have approached, but we got
Where
no
is
remedy.
your approach?
My lord, it was a verbal approach. There was no written
There is
representation
nothing
made by
called a verbal approach in college.
my lord. It is that the mark sheet she received. It is very recently she got the mark sheet, and after that, all this cancellation of studentship happened, and she was in such dilemma that she couldn't make a proper. She did not got any proper guidance to make a proper representation, that she was not aware about it. Being a student, when she got to know that her studentship is cancelled, she was not at all very much guided properly, my lord. So for that reason, she couldn't make any written representation. My lord, if one more thing that I would like to point, if my lord will see the mark sheets in the fifth semester, that is in page number 28, and
Yes.
in the page number 29, my lord, my lord will see that the date of commencement of exam, that is written in the left hand corner in the lower side, in the last portion of the paper. My lord, you can see the date, the commencement of examination date and the date of completion, these are same. So, my lord, a student cannot appear for fifth semester examination and sixth semester examination at the same point of time, my lord. My lord, please consider all these things. I am only seeking a prayer to direct the respondent authorities to allow her to appear for one last chance that is been prescribed by the rules and regulations of the North Bengal University to
You
appear
also
for
made
one-
such a representation before the authority first, before directly coming before this court.
a representation was made by the student, my lord. That is in the page number 34. Prayer for special chance.
The request is for sitting for the supplementary, not the
Supplementary
eighth
examination. That is,
semester.
her studentship is already cancelled, my lord. She is not even allowed to sit
Where is
for-
that order? Cancellation of studentship, where is that?
My
order?
lord, that is in the page number 33. When she's, even if she is trying to apply for the supplementary, she is trying to sit for the supplementary examination, her studentship is cancelled. For that reason,
Where
she's
do you
not
get cancellation of studentship?
my lord,
This says you're not eligible, that may be for various reasons.
yes, my lord.
Does this record that studentship, you are saying studentship cancellation? That is a different thing altogether, right?
Yes, ma'am.
So where is that endorsement that your studentship is cancelled? There is
My lord
nothing
will-
as such.
If my lord will allow me, then I will try to collect some documents or take
Am
some
I
instructions.
clear,
my lord.
right?
Yes, my lord. I am,
You say you are harping on one single point, the studentship has been cancelled.
yes, ma'am.
That has to be revived. So
Yes,
where is that order cancelling the
My
studentship?
lord, kindly give me
This
some time.
says you're not eligible, maybe because of the fact that there are two back papers
papers.
still there. So she cannot appear for the eighth semester unless she clears those papers, right? Maybe that also we are.
That also might
apprehending,
be a-
Yes. So we do not know what has actually happened.
Yes, ma'am.
You need to come back with the documents. Let me hear, Mr. Chaudhary, yes. Is the studentship cancelled?
But that is not the instruction, the studentship has cancelled, because as per the regulation of the North Bengal University, there cannot be a back papers of more than 2. That has to be clear.
This is not more than two, it's 2.
Yes.
So allow her to clear the papers.
But if your lordship see, there are the already chances are also exhausted. Your lordship kindly see page 26. That is the
Yes, 26.
in the fifth semester examination, may not. The political science 5, jurisprudence 11, administrative 15, constitution 2, marks obtained 2, crimes 10, Interpretation of schedule 0. So it's a failed. Examination held on 24 January 2020 at bottom.
Yes.
Then, my lord, what he says, the next page in lordship C, the 5th semester examination, that is, my lord, again in 30th January 2020. Lordship, what is in bottom? That is also even the constitutional law, she could not qualify. Then, my lord, next can come the 5th semester examination at page 28. And say the July 2024 examination.
So this is, she has repeated the 5th semester, right?
Yes, repeated the 5th semester, but the 3rd consecutive chance for the paper of constitution law has been already exhausted. My 2, she could not obtain marks, qualifying marks, and 1 is absent. 3 consecutive examinations.
Where the absent part,
Absent
please
is
come to that part.
28 page. Lordship got it, 28.
This is 5th semester 24.
Past 26, Lordship, 5th semester. 5th semester exam. Page 26, 5th semester. Examination held on 24th January 23. Bottom. Then the below the 5th semester, next page. Examination held in 30th January 2024. After 1 year.
Then again the 5th semester.
Then again the 5th semester, 8 July 2020. 3 consecutive chances has already been called.
My lord, that is the irregularity that was
So,
I was
So
trying
3
to point.
consecutive examinations, 2 chances she was unsuccessful, the last chances she was absent. This might be the reason, my lord. It is not even clear from the repetition, and my lord, even because no studentship has
So will
been.
you come back with the necessary instructions and
But
the, and the
repeat it?
university rules? That
University-
needs to be seen.
Yes, my lord. University
Because the writ code cannot change rules.
yes, university rules is there.
That has to be placed on record.
That
You
by-
say that more than 2 chances cannot be
then my
given.
lord, by an affidavit, otherwise.
You have to, yes.
Yes,
My
by
lord.
this
Since
time-
you say that
but
more
by
than 2
this-
chances cannot be
Yes,
given.
but by this time examination will be over. Examination will commence from 8th July.
So what is your suggestion?
My suggestion is that immediately let him apply before the university stating, narrating all facts. Let university consider what is the reason we must know. Then accordingly, if she qualifies, she will be allowed to appear. If she doesn't, she will not be.
My lord, my
Otherwise,
beloved-
by way of exchange of affidavit, the studentship, I think, the
Will-
special
yes, she'll
exam,
suffer, she'll
the
suffer.
special exam cannot be conducted.
my lord, my
Today we are heard.
Yes, was trying to point out. I'm very sorry to cut you.
It's all right.
Sir, I'm
No,
very
no,
sorry.
no,
Yes, yes, please,
Yeah, I may be wrong, no problem.
Very sorry, sir. Madam, Your Honor, what happened actually, she appeared in the 5th semester examination in the year of 2022. She did not qualify in all the exams. She got back. She was supposed to appear in the next session in the year of 2023. She appeared. Our session happens in July. There is one semester happens, and then next semester examination goes on in around June or July.
What, in
It-
the
it-
second also, she
My
has
lord,
not
what
qualified
happened?
in one paper.
First when she appeared for the 5th semester exam, she got back in all subjects.
That is her first chance gone.
That was her first chance gone. Second chance, she appeared in the next year, that is in 2023.
There also one paper,
There
she
there
did
also
not
one paper
qualify.
she got back. She
that is
got
her
back.
second chance.
That was her second chance. And now what happens? My lord, both the two, if you see, my lord, the two
They are
mark
not the
sheets-
same.
The mark sheets that my learned senior was trying to figure out as her third chance, that is not her third chance. That is the page number 27 is the online mark sheet that I have procured from the North Bengal University.
Sir, I think there is a mistake. Please see, page number 27 and 28 are not the same semester. 27 is 5th semester examination 2023.
Yes, my lord.
The
That is
next
what I'm
is
trying to.
2024.
That is, my lord.
So
That is
this
what
is
I'm trying
what-
to point out. The hard copy when I received.
No, this is not the hard copy of the earlier one.
My lord,
Earlier one is of 2023.
my
The
lord,
hard copy is of 2024. So they are different.
no, my lord. If you see the marks and if you see the subjects, those are same. If you see the marks and if you see the subjects, those are same subjects, my lord. Same marks. But
So
only in
without
the one
wasting
subject.
further, without wasting further time, will you file a comprehensive representation before the authority?
Yes, my lord. If my lord will
File
I
to
will-
the, addressing to the registrar and controller by today or tomorrow, because tomorrow is 4th and 3rd.
She has not yet exhausted her third chance. This is the same mark sheets I am talking. I am trying to point out before the
Maybe
court.
then
my
there
lord.
must be reason of not allowing her to apply in the
Yes,
ensuing
I will,
examination.
I will do the,
There
I will
must-
make
There's
comprehensive
not been any
representation.
physical correspondence, right?
Yes.
Or interaction whatsoever. You have not been able to enter the portal and you've come up before this court. Right? And the
I am-
application that is written to the authority is very cryptic. You have seen that. Nothing is disclosed from that application. You need to file a comprehensive representation. to put
Before
that
the
in.
university.
So-
Straight college has nothing to do with that.
So let me dispose this of,
Yes, ma'am.
directing you to file a comprehensive representation.
Lordship, even the principal, if your lordship see the page 34, principal of the college has forwarded to the authority. Yes, my lord.
There cannot be any malice, right?
Yes, my lord.
So it will be before the controller.
Before both, let them, because university little dicey, to the registrar officiating and to the controller of examinations also officiating. The registrar of North Bengal University.
So that is 2 and 4.
2 and 4.
Respondent numbers 2 and 4.
Yes, my lord, 2 and.
Learned counsel for the, no, sorry. The petitioner is a student of LLB, BA LLB 5-year course in the Indian Institute of Legal Studies and appeared for her 5th semester examination which commenced on 31st January 2022. Stop. No. 5th semester examination, which, where is the first one?
My lord, that is in the page number 26, 2022. She appeared for the first time.
24th January 2023, which commenced on 24th January 2023. She did not qualify in
Any of the paper.
any of the papers and appeared for the 5th semester examination for the second time in
2023. So in the 31, 2024.
on 30th January 2024. 30th January 2024. Stop. In the said examination, she qualified in all the papers except one.
Except, my lord, can you indicate constitutional law?
Except Constitutional Law 2, Roman 2,
Yes, yes.
II. She further appeared for the 5th semester examination
My lord, she didn't appear for the 5th semester
Oh.
examination again.
she
Appeared only 2 times. my lord.
She appeared
In the
for the
6th
6th
exam.
and 7th semester examinations and qualified in all the subjects. Stop. However, she did not take the supplementary tests for clearance in the subjects where she did not qualify. Clearance of the subjects in which she did not, in which she did not qualify earlier. She did not qualify earlier. When she tried to fill up the form, the online form for appearing in the 8th semester examination, she was found to be ineligible for
8th or
appearing in
9th?
the
8th or 9th?
8th semester.
8th, 6th, 7th, she cleared.
She
Eight.
is supposed to appear in the
She
8th
was found to
semester.
be ineligible to appear for the examination. The petitioner seeks a direction upon the authority to allow her to appear for the said examination. Paragraph. Learned counsel for the respondents submits
That's a special chapter. he himself, herself said that the
For the
special.
examination as a special chance. Paragraph. Examination as a special chance.
Yes,
Paragraph, learned counsel for the respondent submits that it is that the documents are not clear as to why she was prevented from appearing for the 8th semester examination. Learned counsel suggests, shall I recall your suggestion?
yes, no problem.
That the petitioner
Always we are for the students, my lord.
may submit a comprehensive representation before the concerned authority stating the entire facts and seeking permission and seeking necessary permission to appear for the examination.
If she is otherwise eligible.
Comma, if she is otherwise eligible. So learned counsel for the petitioner concedes to the said submission. Paragraph in view of the above, comma, the writ petition is disposed of with liberty to the petitioner to submit a comprehensive representation before the 2nd and the 4th
Respond.
2nd and 4th, right?
Yes, yes,
Respondents in this regard.
My lord, kindly specify by tomorrow itself, because the 8th is date.
That is her choice.
My lord, if she on 8th, then she will come back that, my lord.
No, my lord, will not do.
Because it is very, the days are running.
Stopping,
Yes, ma'am.
the petitioner undertakes to submit such representation by tomorrow. By tomorrow, comma, that is, I'll be taken.
Third.
Tomorrow is 3rd July 2024. Stop. The concerned respondent authorities
My lord,
shall
kindly mention 2 and 4.
Respondent, the 2nd and 4th respondents shall consider and dispose of the representation by 7th
7th is Monday. 7th is
Monday, yes, by 7th July 2025, upon affording reasonable opportunity of hearing to all concerned, including the petitioner. Comma, in accordance with law.
Yeah. Disposed of.
Since disposed of, since no affidavit, even I adjust it to the website. Service. Truth evidence service. Political and control. Dispose of affidavit.
My lord, the Gogalatama, my junior will file at the
Department, in the department. Next.
20 minute, I am for the petitioner. For the private.
Yes,
Milord, kindly come page 22 of my writ petition.
have you served?
Milord, this is a copy of sir.
I'm Sandeep Pradhan.
You are for?
Sandeep Pradhan.
Pradhan is the answering respondent. What about, there are private respondents also?
Milord, actually the thing is that.
Have you served the private respondents?
Milord,
For all of them? Very good.
Milord.
Yes, page?
Milord, page 17 of my writ petition. That
Yes.
is a fatta in the name of the petitioner, Milord, Sukamoro Taluka. And the second page, Milord, that is page 18. The exact Khutian number and the tag number is mentioned.
Yes.
164 and 129 by 50. And petitioner, Milord, is residing in that plot with his family, having a residential house. Now, Milord, what happened? The dispute cropped up between the petitioner and the private respondents regarding a pathway. The pathway which is connects the petitioner house to the main road, which is situated over a pond. That road was obstructed by the private respondents after constructing a wall. And in regarding that dispute, petitioner filed one application before the learned executive magistrate under section 133 of the CR. Page 20 was my petition. That petition was filed in 2021. Page 20.
Yes.
In that petition, Milord, on second page 21, paragraph 3 and paragraph 4, I have mentioned my grievance. That the land of the petitioners situates adjacent to the bank, and the pathway of to ingress and egress to the land of your petitioner is connecting the road built on the bank. The road built on bank is the main road, and that what the road is connecting. That the said pathway connecting the road situates on bank is the only way through which the ingress and egress of the land of your petitioner can be done. So that was by facts and para 6, my lord, the allegation that the OPs are the land monitoring and scheming persons after illegally possessing the khas belong to Department of Irrigation by east side of the land your petitioner by taking a chance of helpless your petitioner has intentionally blocked the said pathway by constructing erecting pakka wall of 9.5 feet height on the land of the Department of Irrigation of and your petitioner. So the road is on the land of the Irrigation Department. They have constructed a wall, and that petition was disposed by the learned Executive Magistrate Alipurduar after calling reports from the BLR. May not kindly come page 27. That is the report given by the police.
So the encroachment is on government land, not on your land.
The pathway has been blocked. My ingress and egress, the road has been blocked, and the road belongs to common road. I am coming to that. The report given by the police officials. Milord, in the 1, 2, 3, 4, 5, line number 5, Milord, after thoroughly inquiry, it is revealed that there is a pathway with the boundary wall, which is used by the OP members, over which there is a tension arise out between the petitioner and the OP members. That was the report. And the next page, page 21, that is 28, that is the report of the BLR. Second paragraph. Second paragraph. After physical verification, it reveals that the schedule RS plot 129 by 15, in my patta as mentioned, is situated beside the irrigation dam, and the plaintiff and defendants are permanently residents of that plot. Other local people who were present at the time of inquiry stated that both the parties used the same road, but now OP members have built a big wall which has caused the controversy. And now from this report, it appears that there is a pathway. Now, Milord, the question comes that to exercise the jurisdiction under 133 CRC, it is necessary that it should be a road used by the common people, not to a private parties. So, learned executive magistrate correctly sought for that report, page 29, the order sheet.
Page
29.
Yes.
Second paragraph, it is handwritten order sheet.
Yes.
From the report of the, it is not clear that the road is used by the public. Rather, the dispute appears to be the between the two parties. In this context, LRO is once again directed to conduct inquiry in the light under section 133 CRPC. So fresh inquiry was called for. Page 30, Milord, the next report of LRO. Page 30, Milord, may I?
Yes, yes.
In second paragraph, Milord. Now, after field inquiry, it reveals that the petitioner Sri Sukamal Talukdar resides the dam over Kirkiti, which is reported under the irrigation department about 40 years ago. He made a road over the dam area, which is on the land of irrigation, which was used by the movement of the common people for so long. The problem has been arisen when the defendants made a guard wall over the road forcefully, and the road has been blocked permanently. Now there are several roads around the movement of common people, but forceful blockage of the previous road is found unethical before the local people, and this that means from this report it is appearing that
there is a blockage.
Common people. Yes, there is a blockage, and road was used by the common people. Even Milord, certificates was issued by the local Gram Panchayat. Page 50. Page 50, Milord.
50.
50.
Yes.
Joteshwar 2 Gram Panchayat, Milord. In 1, 2, 10, line number 10, Milord. এই রাস্তাটি বহুদিন সুকমল বাবু ব্যবহার করার পরে তার পাশে এসে আনুমানিক 15 বছর আগে বাড়ি করেন শ্রী কৈলাসবন প্রাইভেট রেস্টুরেন্ট মহাশয়, এবং উভয় পক্ষে সেই রাস্তা ব্যবহার করতেন চলাফেরার জন্য। হঠাৎ একদিন করে কৈলাসের বাড়ির লোকেরা এই রাস্তার উপর একটি গার্ডওয়াল খাড়া করে এবং সুকমল বাবু বাধা দিতে গেলে সেই বাধা অমান্য করিয়া বলপূর্বক চলন্ত রাস্তার উপরে গার্ডওয়ালটি দেয়, তাহাতে ওই রাস্তা চলাফেরা মানুষের জন্য বন্ধ হয়ে যায়, মানুষের জন্য। অতএব কাছে নিবেদন, বিশেষ আবেদন, এই উপরোক্ত রাস্তাটি ব্যবহারের জন্য উপযুক্ত করিয়া দিন। There is signature of the local panchayat member. And recently on 24th April, page 51, Milord, another certificate has been issued. I'm coming to that, why this certificate has been issued. The same contention has been given by the local Gram Panchayat, that was the rasta, that was the road which has been blocked by the private respondents. Page 51. Now, Milord, after considering all these reports, learned executive magistrate passed an order. and directed the private respondents to remove that construction from that road. আমি একটু স্যার শেষ করি আমি যাচ্ছি ফার্স্ট সার্টিফিকেট অফ 2021 page 50 that was previous page 50
Yes,
First
this is
certificate of
2021,
2020.
yes.
page 31 the order of the learned executive magistrate
Page?
31 I'm giving so much pain your lordship.
No, no, no. that's-
It's 31
31, yes.
31 Milord, again it is a handwritten order, and Milord, from the bottom side, considering all the above factors, the executive magistrate thinks fit to consider that the wall unlawfully construction be removed from the public, and magistrate order the OP parties to remove the said guard wall in plot number so and so within 21 days from the receipt of this order. The police is directed to serve the order to the OPs. So this was the direction passed on 15th February 2023. Now there is a fault comes to on my part. After this order, it was passed in 2023. It was communicated to police by the order of the learned executive magistrate, but no action was being taken. But as the petitioner is an aged person, Milord, near about 60 plus, so suffering from some health conditions, he stopped all the proceedings being fed up. Now, Milord, the problem is coming that this is the only ingress and egress way. As the road has been blocked, nothing, no ambulance, no doctor can enter into his house, and he's suffering presently from health conditions. So in 2025, we again approached to the learned executive magistrate with the prayer, a fresh prayer, that please call for fresh reports. If that order has not been executed, then pass accordingly necessary orders. That petition is lying in page number, Milord, 34. 34, Milord. On 20th January 2025, the petition number 28 of 2025, it is pending before the learned executive magistrate Alipurduar. And from
This is still pending.
it is pending. Now, Milord, page 32.
Why
Yes.
was it required?
My prayer is completely different, Milord. Page 32. Now the dispute comes. Page 30.
Yes.
First order of 29 January. Reports was called for from the BLRO and the police officials regarding this matter. 9th April is the next order, Milord. No report has been submitted. First date was in January, Milord. Second date is April. And the next date has been fixed on 9th July 2025. Till now, no report, as per my instructions, no report has been submitted. And these dates are being fixed for after 3 months, 4 months. Now, Milord, I am coming to the statutory point. Milord, if kindly come to section 157 of the BNSS, Milord.
This is very strange. Have you placed the earlier order before this?
Yes, Milord. Yes, Milord. There is list of
Magistrate?
documents. Yes, Milord. There is list of documents. I have filed
No,
certificate.
no, have you placed it before the magistrate?
Yes, Milord.
The second time?
Yes, Milord. Page 38. List of documents I have sir. In that. Page 30.
Yes.
All the previous order, order sheets including patta, everything has been submitted. But Milord, kindly come to section 157 of the BNS. Madam,
I have a book. Let me utilize this also. 157.
157.
অর্ডারটা লাগিয়ে তো
হ্যাঁ
আমাদের ঠিকানা নেই তো ভাই
আছে কপিতে আছে Milord, that 157 procedure where person against whom order is made under section 152 appeared to show cause. 152 BNSS, Milord, earlier 133 CRPC correspondent. Milord, I'm taking to the last, these are the proceedings that magistrate will direct them to show cause why they are not executing the order. Evidences may be taken up. But Milord, the statute at last, after clause 3, it is said, Milord, that provided that the proceedings under this section shall be completed as soon as possible within a period of 90 days, which may be extended for the reasons to be recorded in writing to 120 days. That means the statutory period is 90 days, Milord, and maximum period can be extended with
So your
reason under
grievance
20.
is delay.
My grievance is still, my only prayer is direct the learned
Don't
executive
you
magistrate.
think the delay was caused by you primarily?
No, Milord, after filing this application on 29 January,
There was a previous application, a
Milord,
previous order.
Milord, that was
There
not
had
an
to be an application for implementation, execution. You sat tight over it. You filed a fresh application for a fresh adjudication over a matter which has already been adjudicated.
Milord, for further proceedings. Under 153 of the BNSS for further proceedings, why that order is not. My only submission is that, Milord, kindly direct the state respondents to expedite the matter and dispose that as early as possible in accordance with law. That is my submission, sir. And direct the state respondents to submit the necessary reports which has been sought for by the land executive. That is my submission.
First, by representing the state, slightest of indulgence in matters.
Yes.
Everything, a cluster of stories have been placed before this honorable court. But one interesting fact has not been placed, which is a title suit which has been pending.
I have mentioned in my writ petition.
Yes, it has been mentioned, but no copies regarding the title.
Title suit with regard to what?
Same,
Same thing.
same problem.
They have entirely suppressed the.
This is the biggest suppression of material fact that has been not stated in this.
That is the evidence.
Paragraph number 20, they have stated, but no documents as such has been placed before this honorable.
Please show me the schedule. The plaint is here.
Everything is order.
This is the WS.
With the order,
The plaint.
Actually, Milord, may I submit one thing, Milord?
Please wait. Give me a minute. Where is the schedule?
They have referred the title.
I'm admitting, Milord, there is a title suit, but title suit is a different aspect.
I want to see the schedule, that's
Actually,
why.
Milord,
The property.
presently I have.
Yes. Land measuring 8 decimals, having a small residential structure therein.
That is the residential problem. Not regarding
Oh, and also the pathway.
pathway. Now,
removing
now,
it
Milord,
because-
allow me one submit. Actually, this title suit is actually not maintainable and actually without miscommunication between the learned trial court advocate and the.
Have you
petitioner, this
withdrawn?
happened, Milord.
Have you withdrawn?
Milord, may I speak? Actually, because the pathway is situated upon the land of the irrigation department.
Partly your land also, you say?
No, Milord. It is my land where ends, the pathway begins from there. Now, Milord, it is land upon the irrigation department. As I have no right to claim any title upon the land of the irrigation department, so this title suit is maintainable. Milord, allows us time, we are withdrawing this matter as well. Actually,
After spending so much time, sir, that
Actually-
ought to
actually-
have been said in the beginning itself. After making a full-fledged submission, you are asking for this time.
Actually, Milord, this is completely a different aspect. The title suit, in that title suit, there is no order, nothing is happening. The main.
When a
proceedings-
title suit is pending, the executive magistrate will not deal with the matter. We
No,
should
no,
understand
Milord, as
that.
per 133 CRPC, Milord, section 152 says that no order duly made by a magistrate under this section shall be called in question in any civil court. So this is a completely a proceedings regarding a road, and that is the title regarding the plot of land where the accused petitioner is residing, Milord.
This is your suit. It is not that someone else has filed it.
Milord, I have in that title suit, Milord.
So this is unfortunate. After such a prolonged argument, you are now placing this. And that too, you have not placed it, sir. The respondents are placing this. This is not good advocacy, I must say.
Milord, I seek humble apology, but Milord, this is completely a different thing, Milord.
Can both run simultaneously?
Milord, then kindly allow me time, Milord. I will withdraw that suit and I will come up.
Let him take time because from tomorrow I don't have this determination.
Milord.
Affidavit of service. Heard learned counsels for the parties. Paragraph. This court is informed that a title suit is pending between the title suit being number 133 of 2023 is pending between the petitioner and the private respondents with regard to the pathway involved in the application filed by the petitioner under section 135?
133, yeah.
No, 135 of the BNSS, right?
153 of the.
153 of the BNSS. Learned counsel for the petitioner seeks adjournment to withdraw, to take necessary steps before the learned trial court for withdrawal of the suit. Paragraph, the matter is adjourned.
The opposition filed by the irrigation department clearly states that the property.
The next bench, not this bench anymore.
Grateful, Your Lord.
Next. Yes.
21, my lord, I am praying for 1 week accommodation as because service is not effected, completed, lordship.
I'll just make it not today, because let the other bench deal with it.
Lordship. Good. May I beg your pardon, if it fixed on next week, 21, lordship. The service is not completed,
Since, what? This
21,
is 21, right?
lordship.
21 or
21,
20?
22, madam.
21. Give me a minute.
22.
21 order for 21. Since service upon the respondents is not complete, comma, let the matter stand over till 9th July.
Great. Great.
Next.
My lord, 22, my lord, I am appearing on behalf of the respondent, West Bengal College Service Commission. May I, my lord,
I am
take
from the
it-
petitioner, my lord.
Virtual mode.
Yes,
My lord, I am for the, my lord, petitioner, my lord.
yes.
My lord, the
Yes.
petitioner is a, my lord, assistant professor in English in Karshiang College, my lord. The petitioner was arrested and my lord, he was in custody more than 48 hours. And on that ground, my lord, a suspension order is issued to the petitioner on 9th June 2023. My lord, that is in page number, my lord, 35, my lord. Lord, kindly came to my lord, page number 35. The ground is mentioned that due to 48 hours custody, the petitioner is suspended. And after that, my lord, the suspension order is in the 2023, my lord. After that, my lord, the nothing is happened, my lord. No disciplinary proceeding is initiated. No charge is framed against the petitioner, my lord.
Yes, who is appearing for the college?
I'm for the college,
authority?
my lord.
Yes.
My lord, charges are under section 376, my lord.
Yes, that's a criminal
And
case.
yes, my lord.
What has the college
Promise
done?
to marry, my
And my
lord.
lord, there is also another complaint pending against him, my lord, prior to this, my lord, involving sexual harassment and outraging the modesty of one of the students, my
This
lord.
complaint is before the
No,
college.
my lord, not the student, my lord.
complaint, sir.
Kindly come to page,
That
my lord. I
complaint
have
is lying
annexed the
before the
complaint.
internal complaints committee, my lord.
So I think you need to come back with an affidavit.
Yes, my lord, I'll file an affidavit.
These
My
documents.
lord,
But he's
page
already
number
drawing,
20.
he's already drawing 90% subsistence allowance, my lord.
Lord, I
Without
am appearing.
working.
Myself appearing, my lord, Subramsi Konda is appearing on behalf of the West Bengal College Service Commission. Lord, after recommendation, my lord, the College Service Commission is the authority to, my lord, issue appointment letter. The appointing authority is the college and, my lord, disciplinary proceeding or, my lord, any, my lord, the proceeding has been adopted by the college itself. The College
College
Service
itself.
Commission nothing to do,
No,
my
no.
lord, after recommendation.
Governing body will the, my lord, answering respondent.
So that is, you are for 10,
I'm for 8, 9 and 10, my lord.
8, 9 and 10.
My
So
lord,
they are
kindly-
the answering respondents, right?
Yes, yes, your lordship.
For recording the order, my lord, kindly come to one annexure, my lord, which is annexed to the writ petition itself, my lord.
Yes, annexure.
That is at page 38, my lord. West Bengal College Teachers Security of Service Act 1975, my lord.
Yes.
And the relevant section is section 11, my lord. If I may read out, my lord. Page 41, my lord. The governing body of a college may place a teacher under suspension where an inquiry against him under subsection 2 of the section 9. This is not relevant, my lord. Subsection B, my lord. Where a case against him in respect of any criminal offense involving moral turpitude is under investigation or trial, my lord.
So he had filed an application for quashing also, my lord. No stay was granted by this honorable court, my lord. Though the application is pending, my lord.
My lord, that
College
is a
has-
that is a
Well,
criminal
I think-
procedure. But
I think
I
the
have every
authority
right
needs to come back with
challenge.
the documents,
My lord.
right?
My lord, there is yes, your lordship, that is
Let him
true.
come back with an
My-
affidavit in opposition.
Yes,
You'll
yes.
have your chance of reply.
My lord, kindly give a short date because the petition, my lord, there is a specific Supreme Court judgment that the charge ought to frame immediately. My lord, but the authority has not framed charge, my lord, after 2 years,
Your
my lord. The
affidavit
petition
within 1 week?
My lord, at least 3 weeks, my lord.
Two.
He is already receiving 90%.
2 weeks or
Kindly,
1
my lord,
Learned counsel,
My lord, 2 weeks.
affidavit of service. Learned counsel for respondent numbers 8, 9 and 10 seeks to use an affidavit in opposition in this matter. Paragraph, affidavit in opposition be filed within 2 weeks from
My
date. Stop, affidavit in reply, comma, if any, comma, be filed within a week thereafter. 2 weeks and 1 week. The
yes, your
matter
lordship.
is placed before the next available circuit bench.
I'm deep. Yes.
Myself, Subramsi Pandal is appealing on behalf of the Ojibwe College Municipal.
Please give
Name may be
your
recorded.
number. Please give your, your name.
Yes, sir.
Grateful, your lordship.
Next.
23 appear for the writ petition of my lord. May I find the affidavit of service? Here, my lord, the private respondent 6 and 7, the service has come back incomplete with the endorsement that the addressee could not be found. Now, the issue is, my lord, we are here against a civil suit is
You
pending.
need to serve and come back.
My lord, a civil suit is pending between me and the private respondents here. In the same address, my lord,
My
this
lord,
suit was,
I am
my
for the
friend is
respondent number 6.
6.
What about 7?
6 and 7, my lord, are related.
No, not
No,
related.
they are not.
No, they are not. They are not, but my lord, they have appeared in the code below in the suit,
no.
my lord. They are contesting it.
Why don't you serve the learned counsel at the trial
Kindly,
court?
kindly give me that direction, my lord.
7, for 7.
For
6
7.
he's appearing.
6, my lord.
6.
Affidavit of service. Paragraph, since the petitioner is unable to effect service upon the 7th respondent by registered post, comma,
6.
liberty is granted to effect service upon learned counsel who is appearing on behalf of the 7th respondent before the learned trial court. Paragraph, the matter is adjourned. Next.
24, my lord, I appear for the writ petitioners.
I am applying for the municipality.
May I file the affidavit of service? Here, my lord, the writ petitioners, my lord, are the owners of a property.
State. You're
Now, I am a owner of a we are the owners of a property, my lord. Now, what has happened that if your lordship first kindly comes to page 18, this is a notification, my lord, is there?
notification only. 18, yes.
18. This is the notification, my lord, whereby Kuch Bihar town has been declared to be a heritage town and a list of properties proposed to be included under the heritage has been mentioned, my lord. My name is appearing there, my lord, my property, my lord. Now, here, if your lordship kindly sees the 3rd paragraph, my lord, may I place it? The owners or occupiers or leaseholders of the opposite building, temples, precincts, sites, etc. are at the liberty to give their views, submit claim or objection in writing to the local authority, that is the concerned local municipality, in case of urban area, and Zilla Parishad in case of the rural area within 30 days from the date of publication, and thereafter within such 30 days it has to be disposed of. Now, my predecessors in interest, my lord, if your lordship kindly comes to page 78.
30 days, it has not disposal. It has to be filed within 30 days.
And the next paragraph, my lord. Will submit the views and recommendation to the district heritage committee, my lord. So the next step goes. If your lordship kindly comes to page 78, this is the representation made by my. Yes, there are two representations, my lord. 78 is pending, made by my predecessors in interest, my lord, and next is, my lord, page 80.
This is before the special cell on
The chairman is the concerned officer. Madam.
It's the authority to, my lord, that,
Heritage Commission.
to hear the objection. So lordship kindly send it to the municipality, municipality will. It has already been sent, so let it be considered.
Considered.
It is pending.
Yes.
Yes.
Both my representations.
78 and 80.
78 and 80, my lord.
80.
Eight to,
These are your objections.
These are 78 by my predecessors in interest, 80 by us.
Affidavit of service.
কিচ্ছু বল।
45. তুমি please
Her
take it on.
counsels for
Yeah,
advance.
My lord,
Yes.
I'm seeking leave to my lord. Court number.
Oh, yes, yes. Paragraph.
নাম দিয়েছো?
The
ওটাই দরকার।
property of the petitioners were declared to be heritage property by a notice issued by the Secretary, West Bengal Heritage Commission on 7th July 2019. Views / claim / objections in writing were invited by the owners / occupiers of the properties declared in the said notice. Stop. The petitioners, the predecessors in interest of the petitioners, as well as the petitioners, submitted representations raising their concern in this regard before the concerned authority on
My lord, first one,
17th September,
2019,
17th September 2019 and
22nd of May 2025.
22nd May 2025 respectively, which are yet to be considered. Stop. The petitioners seek consideration of their representations by the authority. Paragraph. In view of the above, the writ petition is disposed of, directing the, who is the authority?
My lord,
Respondent number?
Chairman. municipal.
chairman, my lord, I'll just,
এই,
is my lord, the respondent number 8.
8.
9, my lord, sorry. The 8 and 9, 9 is the chairperson,
So it should be 9.
9, my lord.
Directing the 9th respondent to consider and dispose of the representations submitted by the petitioners / their predecessors in interest within
3 months.
2 months,
2 months, great.
within 8 weeks.
If I ask more than lordship. 2 months.
I'll remember this.
For this purpose.
8 weeks from the date of communication.
Yes.
My lord.
From the date of communication of this order, upon providing reasonable opportunity of hearing to all concerned, including the petitioners, in accordance with law.
Grateful, my lord. My lord,
Since no affidavit has been invited, I will grant it.
my lord, regarding the notification, my lord has been pleased to record 5th of July or 7th of July, my lord, the date.
Notification. So 5th July,
5th July.
5th July was 5th July 2019.
Great.
Notification. Oh, 5th July 2019.
Yes.
Next. 25.
Lordship service is not completed yet.
Since
Your Honor.
service-
Kindly fix it to your next survey.
Next
I,
subject.
I am on behalf of the respondent, Your Honor.
He's appearing.
My lord, I am on behalf of the respondent, IDBI Bank, Kuchbihar.
The respondent is appearing. So you're ready?
I know the case, but senior will continue the.
He's asking for next circuit.
Okay, Your Honor.
On
Okay, my
prayer
lord.
on prayer of the petitioner, the matter be placed before the next available circuit bench. Next. Yes.
I'm for the petitioner, madam.
I beg to appear for the state lordship.
My lord, affidavit of service has not yet completed, madam. One respondent has been received. But
Next week.
Madam, if my lord permit, I may proceed with the hearing.
Without service, you'll proceed with the hearing?
Yes, very
Can you
small
do
case.
that? You have to serve and come back. Since service upon all the respondents, affidavit of service, total affidavit of service filed by the petitioner is taken on record. Paragraph, since service upon all the respondents is not.
Lordship, I beg to appeal for the state, Lordship, in this matter.
Others are there.
Private respondents are there.
Since service upon all the respondents is not complete, comma, let the matter stand over till 10th July.
Grateful, Lordship.
Next.
Well, 27, the act was 27, just, I mean, 29, just. No, no,
Who is appearing? Who is appearing for the state and the private respondent? Private respondent, you are appearing.
2 and 3.
You are asking for disposal.
Well, he has also filed a application for debt recovery tribunal Siliguri. And also simultaneously, he has filed a application before the district magistrate. Both are paid.
Still pending.
Yes, my lord, for the state, my lord, I had a talk with the office of the DM, my lord. They said if a direction is given, they will.
Why is a direction necessary? Please
My lord, I don't know.
take your breath, take your breath. I'll give a
Nothing
direction
further
for
they said.
expeditious disposal.
Yeah.
Well, kindly see paragraph 11, petition. The petitioner also filed an appeal original
Yes,
application.
yes.
Well, for recovery of the debt. And thereafter, they file again an application for recovery. For that, I am time, I am say for that, Milord, I am time 2 days time for ascertain whether this time period proceeding is maintainable or not. For that, I am taking 2 days time, Milord. It is fixed, Milord, on fixed on 10th July, Milord, 10th July, just 10th July. 2020. Once.
If he wants to come back, let him come. Affidavit of service, learned counsel for the.
And also he has filed an application.
If it is maintainable.
Yes.
He is on maintainability. Let him come back. Learned counsel for the third respondent seeks accommodation. Affidavit of service is ordered.
2 and 3. 2 and.
You are 2 and 3.
2 and.
Learned
Who is the
counsel.
district magistrate?
No.
Learned counsel for respondent numbers 2 and 3 seeks accommodation. Paragraph, the matter is adjourned. I cannot fix a date. Take it. Next.
I am for the statement.
Yes. Private respondents?
The owner of the land and he contracted a building location, respectively, and construction of the commercial and construction of the residential. In the
Yes.
same building location, the private respondent passes the flat process, and all of a sudden in the year that 10 years back, in all of a sudden, he complained that there was a mobile tower to the complaint of the SDO. And after inquiry, the complaint is found false. And no action was taken to the against the and thereafter they forcefully and in the safe building of the petitioner lease agreement with the Geo company in the year of 2015 14 I have annexed the documents lawsuit. 2020
I did not follow the petitioner.
Yes, sir. Lease agreement with the
With Jio, yes.
company. And the private respondent forcibly and deliberately resistant to the Jio company employees to enter into the filling. So that is rented. And in the circumstance, I filed a complaint, written complaint to the district and local police. They did not take any action. Thereafter, I filed this read application and paying for and paying for who operate the state flat company.
It's a civil action.
No, I made a complaint to the jeweler.
How is the writ maintainable? Where is the public element? It's a private dispute between you and your owner or tenant, whatever you say. Where is the public element in this? How is the writ maintainable?
But I made a complaint to the
How?
jeweler, but they did not.
How is the writ maintainable? You are talking about a private dispute.
Yes.
Withdraw. I have to dismiss this on the majority. Any private dispute, the writ court can give a direction for consideration. That's what you say. Please don't take chances before the High Court. What instruction? I know if it is not today, you are saved from me, I know. Because from tomorrow I'm not there. Very well, not today. Let me not hurt your sentiments. Next.
The 29, I am for the petitioner.
Yes.
29, the petitioner is an assistant teacher of a school situated at Jalpaiguri. Her residence at your lordship kindly turn to page 35.
Have you served?
Yes, I have served.
Mr. Shah is there? It's only the state.
Main answering respondent state, my lord, the DI.
The headmistress, where is the service?
My lord, main answering respondent DI.
Where is your track report? Track report. Private respondent. Where is the headmistress? Yes. Where is the service? Oh. Service is not complete.
My lord, the main answering respondent, district inspector of school, state respondent. Only, my lord, I have any very innocuous pair. Your lordship kindly page 35. My lord, the petitioner applied for
service, however innocuous a prayer is, how can I do it? That becomes a ground for appeal, sir. We must understand that. Please serve and come back. Since service upon the...
Kindly fixed on Monday, my lord, so that I can serve, my lord, by tomorrow.
Let it happen next week. Since service upon the 7th respondent is not complete, let the matter stand over till 7th. 7 July.
Next. Matter 7 July. That report
Since you have implemented him as a party, you need to serve.
And for the state.
No one for the private respondent. Since service upon the private respondent, you can delete his name then in that case, no. FIR is against him, right? He will be affected.
Thereafter, my lord, the petitioner lodged a complaint. The entry was proper on past of thereafter, after 7 days, my lord, the petitioner lodged a complaint before the Adjournment police station on 29th. But my lord, Adjournment police station was not make any complaint regarding that. We have not either given any receipt call. Thereafter, day by day, petitioner went to the Adjournment police station. Thereafter, my lord, 4th of January, Adjournment
has been registered. But my lord, what Alpudar is saying on 4th of January 2020, another complaint from Eviction has been made. Your lordship. My lord.
So if an FIR is not registered, you have recourse to 156(3)?
But my lord,
You cannot come before a writ court.
Alpudar police station registered another person's paper. And my lord, upon the charge sheet has been submitted. But upon IFR, they did not acted upon.
What further course have you taken?
My lord, I went to the
Where, and then after that,
after that,
156(3) comes into play after that. Writ court cannot entertain. There are specific provisions.
There are specific provisions, but there was a question of judgment, my lord, when the report directed.
Well, we'll serve the private respondent in any event. My humble view is that it court cannot. 156(3) is very clear. Since service upon the private respondent is not complete, let the matter stand over till 8th July. Next. Yes. Service.
It's complete.
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 Very difficult thing to blood this matter.
My lord,
So you should be appearing for all of them, all the respondents.
yes, all of them. So I'll just place before your lordship what the case is all about. My lord, in 2019, the government of West Bengal, by way of a notification, constituted a special task force, STF. Now, going by the notification, the STF is empowered to investigate into certain specific class of offences, narcotics, counterfeit currency, terrorism, etc., 6 or 7 heads, arms. The 2019 notification says that this STF is being constituted in exercise of powers under Section 2 of the Police Act, read with Section 2 of the Bengal Police Act. Those two enactments are annexed with the writ petition. On a plain reading of it, I cannot trace any power to constitute a force within a force by means of these two notifications. That is the first question mark. The second question mark is, sometime in 2016, for the purpose of this STF, the government, by way of a notification again, establishes 2 police stations. STF Siliguri Police Station at Shaudangi District, Jalpaiguri, STF Bidhannagar Police Station. Now, whether this act of creation of a police station by saying that your local area includes 8 districts of the north for Siliguri and 9 districts of the south, that whether that can be done, that is the second question mark.
How are you personally affected?
We are all advocates of the Jalpaiguri Bar Association, the three members. We are affected by the third question mark, which I am going to place before lordship. The third question mark is, pursuant to this notification, after this notification was done, 2 FIRs, 2 police stations were established. The government has now come up with a proposal of assigning jurisdiction of all cases investigated or taken up by STF within all the 8 districts shall be tried by the court in Siliguri. Now, we are affected by this. Now, we are saying this, that conferring of jurisdiction on a particular court or taking away of jurisdiction of particular court is an essential legislative function which cannot be delegated.
So the matter is either of a representative character
I'll just,
or
yes,
public interest litigation.
I'll just say this, I am covered, I'll just place 2-3 judgments where the Honorable Supreme Court has clearly indicated that when an interest is likely to be affected and a glaring illegality is brought before the court.
Interest of whom?
Interest of the petitioners, because kindly sees, for at least 6 to 7 special acts, all the matters for trial
goes to Siliguri court.
Goes to Siliguri court, and this is not only for Jalpaiguri. The aggrieved advocates are not only from Jalpaiguri. The entire Alipurduar, Kuch Bihar, Dinajpur, Malda, so far as Siliguri is
exactly
concerned.
why I say
Yes.
that this is in a representative character. or a public interest litigation?
May not be, my lord. I'll just, my lord, place 2-3 paragraphs of the judgments if your lordship allows.
Because you're not in your personal capacity.
No, I'm not in a personal capacity and also in my personal capacity, as well as I represent the interest of several other lawyers, but personally I'm also
Personal
affected.
capacity cannot be affected.
Miller, kindly, Miller, takes this, Miller. Miller, I'll just place, Miller, 2-3 judgments if my
And
lordship.
this will, I think, before you take the pen,
Yes,
Mr. Ghosh, I think
yes.
this will take some time to deliberate upon.
Yes, yes.
So
But
this is
I
not
strongly,
in this determination.
But
So
I-
I don't think I should take up the matter.
Now, even suppose now even it is not falls with the MB of PIL, then Miller, it requires to be disclosed. What is the stance of the government? Why some?
You want to come back with an affidavit?
no, Millard, I'll be, Millard, seriously pressing my interim prayer so that this proposal be kept on hold because they have already started transferring cases.
I'll just make this not today. Let the court who deals next week can deal
Right,
with the matter.
right,
Because
right.
in a day, I don't think I can solve the issue.
But since Millard has heard, will Millard,
No question of part heard. I dread that send that coinage part heard. Because every time what happens is I carry cases from my earlier determination to my present determination. So no part heard. Not today only.
grateful.
I could have-
Affidavit direction can be.
No, Millard, I'll be pressing for the
He
interim
doesn't
prayer.
want, so let.
I'll
it
be
be.
pressing for the interim prayer.
I would have loved to hear. It's a very interesting
Yes.
issue, but I'll not be there to hear this. Next.
Grateful.
Yes.
I'm for the petitioner, my lord. My lord, in this matter,
State, you're the thing. Second July,
In my belief, it is the third.
not today.
And also instruction is required. It has gone to a hospital.
Not today, so come back tomorrow with the instructions.
Tomorrow, no, and they'll fix it for the next.
completed, my lord.
Will you come back
Not
next?
only the question of completed service.
So you're appealing for the respondents, so no question of service.
Yes, the service is there.
He wants to take instructions in this.
So the next.
Learned counsel for the respondents seeks to take instructions in this paragraph and let the matter appear under the same heading on 10th July. Next.
Lordship, here I am appearing on behalf of the petitioner. Mr. Taposh Bhattacharya is
But
appearing.
yes, I'm for the petitioner.
Yes.
Yes, sir. But the plaintiff's application, plaintiff has come challenging the order, rejecting the application for
served?
amendment. I have served.
Who is appearing?
Last August also nobody appeared. Last August on 9th April, 10th September 2024, nobody
Who is the
appeared.
state? Who is appearing? No one is appearing in the. Where is the service? Please show me.
Lordship, the affidavit of service
Affidavit service there. I have served.
and along with the supplementary affidavit also.
Yes, that's a direction passed by my Lord Justice Rajchandra on 10th September 2024.
Yes, it's
Liberty was
have you
given
served
to-
the GP's office? Have you served the GP's office?
I served upon all the opposite parties. Evidence is there.
Difficulty is service is not on the GP's office. So
The
there is
GP
no
office-
instruction.
But
Please
I
serve the- I'll
Well, I
make
am
it
sub-
not today only. Please
Or
serve the
in-
GP's office in the meantime. Please do that today.
Lordship, can we place a supplementary affidavit of service?
I'll just make it not today. Give that tomorrow.
Tomorrow maybe some difficulty. Want to keep it on Monday.
Monday.
Keep it on
Very-
Monday. Yes, my Lord?
Yes, affidavit of service. On prayer of the petitioner, the matter is, you can give the supplementary affidavit.
That's a supplementary.
And affidavit of service. And affidavit of service filed by the petitioner are taken on record. Paragraph on prayer of the petitioner, the matter is adjourned. Let the matter appear under the same heading on 8th July, Tuesday.
The Tuesday I have a part matter that is going on. The code number 8. I'll be engaged in the throughout the day. That code.
When do you want it?
7th.
7th.
Monday. Yeah, 7th.
7th.
Monday. Yes,
Next.
I've got to run.
Oh,
But I'm for the petition.
34, Mr. Deepak Datta, senior advocate is appearing for the opposite party member.
Yes,
This is transfer for proceedings.
Only paying now.
not today. Next. 35.
Madam, I'm appealing for the opposite party.
Will be appearing in virtual.
Yes, my lord, I am appearing for the petitioner.
Yes.
My
Opposite
lord,
party?
Yes, my lord, I'm appearing for the opposite party.
Very well. Yes.
my lord, the matter is, the suit is for eviction under the Premises Tenancy Act. I am the defendant tenant in the suit. 7-1 application, in the 7-1-7-2 application, I could not deposit the rent. And my defense has already been stuck off in 7-3. Now, the suit has been posted for peremptory hearing. Trial has not been commenced yet. The plaintiff has not filed his document and the examination chief. In the meantime, I have filed one application under Order 6, Rule 17 for praying certain amendment. My amendment application is on page number 24, my lord, Annexure C. Only on 2 aspects. That is, that notice is bad in law, notice is not maintainable, and notice is bad in law. And number 2, on the point that the suit has been wrongly filed, not impeding the other legal heirs of the one of the tenant. In fact, admittedly, the rent receipts are there. 2 tenants had been inducted in respect of the suit premises. One of them died, and the daughter-in-law of the another tenant, she has only been made party in the suit.
Can you contest on factual aspects?
Yes, only factual aspect.
Can you contest on factual aspects except the notice? After your defense has been struck out?
I can, my lord, I can, because the maintainability of the suit can always be taken in any of the suit. Even I cannot disclose any other fact. Since my defense has already been struck off, that's why, like my lordship will appreciate, I cannot take any other defense except these 2 points, that is, the suit is not maintainable and notice is bad.
I think only the second point can be taken by you, not
Yes,
even the
ma'am.
first point.
Yes, lordship maintainability also, maintainable also. I am having with the Supreme Court judgment.
Please place it.
Yes. First, I am citing my colleague's state is there. AR 1977 Calcutta 110. It is a full bench decision.
Mr. Das, can you please cite the cost item? Because many
Yes,
of
it is Guru Das Vishwas versus Charu Pannasil.
Yes.
This is a reference matter, my lord. That's why the division bench pronounced this judgment. Paragraph number 8, paragraph number 34. 2 points was raised there, whether after striking of the defense, the right of the tenant defendant in any eviction suit, whether it is permissible or not, and full bench came to the conclusion, yes, defendant has the right to cross-examine the plaintiff's witness and to place his argument on these 2 points, that is the maintenance of the suit and the question of notice. Because this is the
Where is the issue with regard to maintainability? Paragraph
That was
8
not
doesn't
there.
say so.
In Gurudas Biswas, the issue was whether the right to cross-examine after the defense has been struck off remains with the defendant or not.
yes, cross-examination regarding these 2 points, maintainability of the suit. Because
Where is that in the judgment? I do not find it.
This is not. I humbly submit it is not there. With due respect, it is not there. It was only to the point whether the defendant retains the right to cross-examine after the defense has been struck off.
That can be done only on the point of notice.
Yes, yes. Only point of notice. And this judgment was, I'll place before my lord, this judgment was considered by the Honorable Supreme Court in Modula, India versus Kamakta Singhdeo, reported in 1989, AIR Supreme Court 162. All the previous judgments were considered and the conclusion was drawn, which still now prevails. I'll come back with that, my lord.
If learned counsel wants to come back, he can.
No, I am prepared, my lord.
No, I am prepared. I am prepared. Paragraph number 8 and paragraph number 34, yes, that was reconsidered and that was practically.
8 doesn't speak of maintainability. Let me see 34.
In 34, the answer was in affirmative that yes, the defendant has the right to cross-examine the plaintiff's witness.
Only
on the point.
notice point.
I am coming. I am coming. I am coming, my lord.
Judgment.
I am coming, my lord. So in the notice point, I have every right to put any question, and so I want to add some line in the written statement that notice is bad in law.
Only
Number
to that
1,
extent it can be considered, not beyond that.
No, I am coming, my lord. I am coming. Give me some opportunity, and I am citing another decision, that is Modula India 1988, Volume 4 SCC.
But this judgment doesn't help you. I'm sorry.
In notice point that will help. In notice point my amendment application was.
There is no dispute. I don't think learned counsel is disputing on notice point.
That can only be questioning during the cross-examination.
Yes, obviously. Because if I don't have any denial in the written statement, the question may come at the time of cross-examination that you don't have any right to even.
The issue, my lord, with humble, with due respect, my lord, and humble submission, my lord, the issue before your lordship is, after the defense has been struck off, whether the written statement remains on board is not, is also there. Now, in Modula, India, the Supreme Court has decided this issue, which was cited by learned counsel.
Just a minute. In 1988 Supreme Court cases, page number 619,
yes,
Modula case, paragraph number 13B. My lord, please come in paragraph number 13B, page number 638. 13B.
Yes, this
This
is
is the
absolutely
background.
against you, sir.
Yes.
No. Defense being struck off does not merely mean the exclusion of the restatement of the positive case, if any, which the defendant wishes to plead. It means also the exclusion of almost the participation in the suit. I don't have any right to participate.
Your WS goes, in addition, this also, it's conjunctive. Does not merely mean, but also, that is conjunctive.
No, I don't have any right to give any evidence. I admit. But
your WS also goes in terms of this judgment.
Yes, ma'am.
Yes. But I have the right to cross-examine the defendant witness.
Let me suggest something. Please
Yes.
come back. This is, my determination changes from tomorrow. So let me not deliberate on this.
I don't have any idea.
Yes.
Lordship.
There has been a change of determination. So let me not deliberate on this issue in detail today. Let the honorable judge who comes, who deals with this determination from tomorrow, let him deal with it. If you agree, let me make it not today only. Since this will take some time, some deliberation.
If your lordship is not
a
taking it
purely legal
today, my
issue.
lord, kindly make it next week, my lord, because I have a difficulty this week.
Very well, because it's a purely legal issue.
Yes.
So, needs some deliberation.
Yes.
Yes, I hope you agree.
Yes, sir.
Uh, 9th July?
Yes, my lord. No difficulty.
Yes, 9th July.
Lordship.
5% of the parties let the matter appear under the same heading on 9th July 2020. One more matter, is it short?
Transfer of matrimonials would have played.
Serve.
Service is not completed.
Not complete?
Not completed.
Since service upon the opposite party is not complete, let the matter stand over till 10th July?
Grateful. But there may be a short stay of the matrimonial suit.
Yes.
There may be a short stay.
When is the next day before the trial court?
That is not ascertained. That had not been ascertained.
So unless there's a date earlier, I don't think a stay is required. From 2 p.m. criminal matters, the other bench's determination, which becomes permanent from tomorrow.
জিজ্ঞেস করে নিতে
Lordship, may I be permitted to mention one matter, your lordship? Vacating applications have been filed
Which
against the
matter?
CRR matter, your lordship. Your
Mentioning tomorrow 10:30, not today.
My lord, I understand.
Call the list, please.
But I understand your lordship's difficulties even. My lord, I have some difficulty. The state had taken out a CRR application, who is the interim order passed for making a payment by the SP Jalpaiguri for a 28 lakh, which is my lord, perverse order. My lord, I have taken out that. My lord, that is by Friday that has to be complied with. So my lord, my item 65, I'm not
Alert
placing
mention
today.
is today, please mention tomorrow and consider.
Tomorrow,
It's appearing in the list.
yes, my lord. Tomorrow, then kindly take a
Let me
tomorrow.
see, let me see. I'll call the list tomorrow, let's see.
All right, no problem. I have no problem. This matter is taken up. But the CO is also, your lordship is not taking up.
Only criminal matters.
Only criminal matter.
You don't have a copy of the.
Yes, I
revised-
have seen that.
Revised
Yes,
assignments.
I have seen that. My matter, which your lordship had fixed that.
Revisions, anticipatory bails and POXO and NDPS bails.
Yes,
These are allowed.
these are.
Yes, call the list, please.
Yes, ma'am. As per the order.
Please, please. Who is appearing?
My lord, I'm for the state, my lord. Now, there was a, this is a group 2 matter, my lord. So, my lord,
Is
determination.
it an
by-
assigned matter?
Group 2, yes, ma'am.
School teacher.
No, is it, it is not assigned to me?
No, no,
So I have to release this matter, sir, I'm sorry. It will go to the group 2 bench.
That's
No,
what
group 2 থেকে সেন্ড করলো স্যার এখানে।
Now determination has changed. আপনি এর আগে যে বেঞ্চে মুভ করেছিলেন ওই বেঞ্চের গ্রুপ 2 এর ডিটারমিনেশন ছিল। আমার
Group two-
নেই।
স্কুলটা কি? স্কুল রিক্রুটমেন্ট?
গ্রুপ 2 I think, is it?
না,
he has written, my lord. It's in there.
স্কুল রিক্রুটমেন্ট গ্রুপ
Written over there.
এটাই হবে। ওখান থেকে বললে কেন?
সেটা গতকাল অবধি একরকম পরিস্থিতি ছিল। সিচুয়েশন চেঞ্জ হয়েছে আজ থেকে।
লং
এই
পেন্ডিং
কোর্টে
ম্যাটার।
শুধু ক্রিমিনাল ম্যাটার্স হবে অনারেবল চিফ জাস্টিসের ডাইরেকশন। আমি এর বাইরে তো নিতে পারবো
লং
না।
পেন্ডিং
The
ম্যাটার।
matter be released due to lack
রিলিজ
of
দ্য
determination.
পিটিশনার।
আবার mention করলে হয়ে যাবে ব্যাপার।
পারছি না তো আর।
আমি বলে দেবো,
পাঠিয়ে দিন, ইমিডিয়েটলি পাঠিয়ে দিন, আমি রিলিজ করি। নট টুডে কেন করবো? গ্রুপ 2 আমার ডিটারমিনেশন নয়। নেক্সট। Yes, item 2, anticipatory bail. Petitioner? Yes.
This is an application for anticipatory bail.
Yes.
Not be quantity is intermediate of narcotics, my lord. Brown sugar, 106 grams. My lord, I'm praying for anticipatory bail because my name has transpired from the statement of the co-accused. Yes. My lord, I'm just placing.
There's no other implication.
No, till now, because the case was lodged on 3/5/2025, initial stage. My lord, I'm placing an order of a coordinate bench, my lord.
Not necessary.
Yes. He is the person who has sold the articles.
This is the co-accused statement.
No, sure.
Nothing further.
No. Regarding him, the involvement is there that he sold the
Yes,
contraband.
this is the statement of the
Statement.
co-accused. No other
No,
independent
till now, no.
investigation.
No.
Heard learned counsels for the parties. It appears that the petitioner's name has transpired. No recovery also from him.
No, Lordship. Page
The
19
petitioner's
is
name
the
has
list from the
transferred
co-accused.
The statement of the co-accused. Stop, no recovery has been made. from the petition. Paragraph in view of the above, this court is inclined to hold that the petitioner has been able to rebut the presumption under section 37 of the NDPS Act and is entitled to anticipatory bail. Paragraph accordingly, accordingly, in the event of arrest, the petitioner released on bail on furnishing bond of rupees 10,000 with 2 sureties of like amount each to the to the satisfaction of the arresting officer, subject to the conditions laid down under section 482(2) of the Code of Criminal of the BNSS. Stop, the petitioner shall appear before the jurisdictional court and pray for regular bail within 2 weeks from date. CRM disposed of, case diary be returned, registered by the
Appearance.
rebut the presumption laid down under section 37 of the.
Repeat.
Next.
My lord, I'm praying for not to.
Not today. Hey, Krishna, list চলে গেছে। Next.
সিঁড়িটা ওখানে আছে।
My lord, I am for the petition. For my lord.
Yes.
My lord, on the basis of statement of Coercive, petitioner name transpired, my lord. Principal
No
is tasked-
recovery?
no recovery from the present petitioner, my lord.
Yes.
There are call details record, my lord, from where it is transferred that they have a constant phone calls with the persons from whom the goods have been recovered.
There was no recovery from it.
No, no.
There was no recovery.
No recovery, my lord.
Independent evidence is there.
My lord, kindly submit. I also want judgment, one coordinate bench, our high court, my lord. Call details, mayor, telephonic, mayor call, not relevant, my lord.
No, no, has to be connected.
Yes, my lord, it has to be connected, my lord, one order. It also
The ticked call numbers are this.
My lord.
Patent petition name
These
is
are
Suman.
These are 86, 89, page 138 to 145.
These are
And-
calls between whom?
What is the call between this petitioners and the petitioners from whom the ganja was recovered?
My name is Suman Borman, my lord. I see. And recovery made, my lord,
Recovery made from?
Raju, my lord.
Caesar list is page number 11, my lord.
No, no, but the call doesn't relate to any Raju.
Raju for is the principal accused, my lord. And mayor telephonic, my lord, not a ground, my lord. I handed over the order sheet, my lord. Our coordinate bench decision, my lord. Mayor, except no other incriminating material, my lord, there is no money transaction, nothing, my lord. Mayor telephonic, my lord, not a ground. Our coordinate bench observed, my lord. And also observing another
Where is
decision.
the principal accused's name in the call details?
Raju Rajbhar,
Please show me.
my lord.
Now, page 2, second paragraph. The code of the.
This is bail, this is not anticipatory
No,
bail, sir. Please do not miss these
Page
orders.
number 88.
Come for bail, I'll grant.
No, okay, there is no. Any
What
other.
this I'll reject.
Well, not a ground.
Raju's name, where is it?
Details are there. First we have given, then we have collected the certificate also from the.
Come for bail, not
My lord,
Vodafone.
kindly make it not today, my lord. I ascertain
no, no.
many other judgment, our high court
No
and
judgment
another high
because
court,
this is
will
the,
one day.
this is the
I am not
detail from
letting-
the Vodafone,
My lord,
from the
not-
nodal officer.
Not today.
Not today,
I will
since I'm
satisfy-
inclined not to.
Yes, my lord, yes.
Let him come.
So, my lord, I will satisfy your lordship.
Please don't come with bail judgments.
No, my lord, not.
Look, this
Next.
is the confidential report from the Airtel company.
Come
Malak.
back
This
to
is
it,
also
come back.
there.
Come back to. He says despite this, it can be allowed.
My lord.
That's why I'm giving him a chance.
My lord.
Next,
It's a matter of trial, my lord. Whether
let him come back, let him come.
Your lordship, I'm for the petitioner.
Yes,
I for the state part.
yes.
Your lordship, in this case, basically there are 8 accused. And the principal accused, he's already behind the bars. It's almost 2 months. And I'm praying for bail for this co-accused, whose role is nowhere involved. She is
It's
a mother
murder
of...
case, yes.
Yes, your lordship. And she's a mother of 2 minor children. And when this incident took place, it was in bright daylight during 14 hours in the afternoon. She at that moment was not present in the alleged incident where it took place. And the place where this incident took place is almost 1.5 to 2 kilometers away from her residential area, your lordship.
She is nowhere involved. Moreover, your lordship, the charge sheet also has been filed and there is no specific allegations against her, your lordship. The alleged weapons were also recovered from the possession of the principal accused, who is already behind the bar, your lordship. And one female co-accused is also already on bail, your lordship. She has no role anywhere in this incident, your lordship. All the injuries were also inflicted by the principal accused.
Charge sheet submitted?
Yes, your lordship.
Yes, her implication.
Hello. All the several 161, 164 of the eyewitnesses is there, my lord. She is the one of the eyewitness and the co-injured, my lord. This is the statement, my lord. The name of the present petitioner, my lord, it was transferred. And my lord, total 7 accused person, my lord. Total 7 accused person, my lord. One is in bail, one is in custody, and other are absconded, my lord. It's a case of brutal murder, my lord.
But your lordship, she has no role anywhere in this incident, your lordship. At that time when this incident took place, she was at home with her 2 minor kids who had returned home from school, your lordship. And the PO is 2 kilometers, almost 2 kilometers away from her residential area, your lordship.
Wife of Subhas. All the statements. 161 and 164 statement, wife of Subhas. It was written, my lord.
Where is wife of Subhash? I do not find in this statement.
The 161 statement, last page, my lord, last page. My lord, can I get back to this
Shubho,
case
her
then?
wife Bobby, named him. This is not Bobby. She's not named
My
in
lord,
the statement that you've placed before
Try to
me.
get back the.
Any other statement?
My lord. Ah. My lord, may I get back the case then? My lord, I'm
Please,
indicating.
I do not find her name here.
Yes, it will be in the case later.
Your lordship, the principal accused is already.
Please, some patience.
Yes, your lordship.
Remove.
So much time for a single matter.
My lord, what, all the 161, my lord?
Nothing in 164.
164. My lord, no 164.
And no recovery from her, right?
No, your lordship.
Cheler bou.
Who is this Chelebo?
Name has not been mentioned, my lord.
Chelebo is not there. That's Chele, comma, Bo. So it's the wife of Nimai Shorkar, not this person. We need to read them carefully. Where's the other statement?
Onwards, my lord. Onwards, 164, 161 onwards, my lord.
She's not named. Heard learned counsels for the parties. Though this is a case of brutal murder, the petitioner has not been named by the witnesses in their statements recorded under section 161/164 of the Code of Criminal Procedure. Stop. The offending weapons have not been recovered from the possession of the petitioner. Stop. Presence of the petitioner at the place of occurrence at the relevant time has to be assessed at the appropriate stage of trial. Considering the material available before me, comma, this court is of the view that the petitioner may be granted anticipatory bail. Paragraph, in the event of arrest, the petitioner be released on bail on furnishing bond of rupees 10,000 with two sureties of like amount each to the satisfaction, local to the satisfaction of the arresting officer, subject to the conditions laid down under section 482(2) of the BNSS. Stop, the petitioner shall appear before the jurisdictional court and pray for bail within 2 weeks from date. Disposed of, case diary will return as Senator Coercive. Next. Yes,
Lordship, page 13 is the Caesar list. It was the contraband article seized from one Nipen Roy. Page 13.
there was a direction for personal appearance. Where is the investigating officer?
Question, 4 pages were missing from the case diary, and it was detected, and that's why I informed the learned court, and he said that the trial court, they kept it the trial court, that's why.
CD copy, how can we be shifting the trial court?
Part of the CD kept in the trial court.
That-
How is that possible?
Exhibit হয়েছে document.
না, না, কি করে exhibit হবে?
How
Trial-
can CD be exhibited?
No. Oh, photographs, Lordship. Oh, inventory photographs.
Yes, what is the case?
Lordship, page 13 kindly. The Caesar memo of the BSF.
What is
seize-
the?
Contraband articles
Oh.
seized from the area by the BSF, and one person was detained, Nipen Roy. Page 13, Lordship, kindly. Name of person from whom item seized, Nipen Roy. What is, Lordship?
Yes.
Now, page 14, the 13A, next is 13A, 14. The
Coercive statement.
No, yes, Lordship, co-accused statement. This, it was received by the police, page 14, finds the signature of the accused, Nipen Roy, in just below.
Yes.
Lordship is a fact, but the thing is, your lordship, the incident happened in the border area, and.
Their implication.
Yes.
No implication, only co-accused statement.
Of course.
No recovery.
Recovery from the another accused also. But I stated that he was the gang and doing all these things.
Investigating officer is, but there is no independent implication, right? Report submitted, the investigating officer is present in court. Report submitted by the investigating officer is taken on record. Paragraph, heard learned counsels for the parties. The names of the petitioners have transpired from the statement of the co-accused. No recovery has been made from them. In view of the above, comma, this court is inclined to hold that the petitioners have been able to rebut the presumption laid down under section 37 of the NDPS Act and are entitled to anticipatory bail. Paragraph accordingly, in the comma, in the event of arrest, paragraph 4. The petitioners be released on bail on furnishing bond of rupees 10,000 each with two sureties of like amount each, comma, to the satisfaction of the arresting officer, comma, subject to the conditions laid down under section 482(2) of the BNSS. Stop, the petitioners shall appear before the jurisdictional court and pray for regular bail within 2 weeks from.
Grateful, Lordship.
Report may kindly be kept in record.
Grateful,
Next.
Lordship.
I am for the.
Lordship, praying for 1 day accommodation, so CD is not available.
Not today. Oh, live streaming of Box. No further live streaming.